Yes, yes. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಸಾಹೇಬ್ರದ್ದು?
ಇದೆ ಸರ್,
ಇನ್ನು ಬಂದಿಲ್ವಾ?
ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಹಾ, ಸರಿ ಸರಿ.
Yes. From the last.
$18 is one where an application under order 7-11 was rejected in a custody case. The divorce case pending between the same parties has been stayed by the Supreme Court, filing a memo to that extent. I've served a copy of the.
Take that. Yes.
Year 2022, order was passed to deposit the maintenance before this court. Since then, I'm not being permitted to withdraw the amount. Looking for, I filed an IA to withdraw the amount.
Tuesday. Yes.
My lords, I am for the petitioner in this case. My lords, we have, the respondent has filed a criminal miscellaneous and for maintenance under 125, and they are also filed in a section 25 under Family Act, Family Code, saying for the maintenance, in both the cases, the maintenance has been granted. In the section 25, we have challenged before this court. In the last date of hearing, they were saying there was settlement, but they came with an application in trial court saying that the proceedings maybe they filed a stay proceeding saying that the maintenance has to be paid.
Yes,
before.
Wednesday, yes.
I have filed a writ petition today, my lord. I filed a writ petition today, my lord. This is the case of a petitioner who is a judicial officer and he has not been given an opportunity to conduct an evidence through video conference. And it has been rejected, Your Honor, with the cost of rupees 5,000. So
That I didn't get.
the petitioner is a judicial officer and he has filed a case before the Honorable Trial Court for divorce. And
Does it matter whether he's a judicial officer or he's like any other? That's not a relevant fact to be
yes, my
mentioned
lord,
there.
but he has not been given an opportunity to conduct an evidence through video conference. So
So what is the urgency with that? And this court is not permitting also video.
the court is
conference.
not permitting, Your Honor.
This court is not permitting.
Kindly,
So, even if you file now, a permission is granted unnecessarily, your matter will be dismissed. Let it come, yes.
kindly pose the matter on Tuesday.
Unless and until office objections are complied with,
Okay.
court will not, none of the matters shall be listed. That's the general direction, yes,
And matter is a MFA CPC, my
Huh?
lord. MFA CPC,
yes.
the fresh matters, my lord. Suit for partition.
All that fresh matters, if the office objections are complied with, immediately they will be
In this
listed.
case, my lord, the application filed before the trial, plaintiff, you file an application under such.
Any office
Adala, yeah,
objections,
the-
if you want to say anything, you can
For
say that you will
maintenance,
make a
raise the
submission
objection
for the
before-
court.
The office raised the objection for maintainability, my lord. That is
That
it.
you can say that you will submit it before the court, then it will be posted.
But it's not posted already.
You have already said that wherever there is a council submission, let it be listed. Look at it.
How to write.
Look at that. If at all he has said so,
Still I am not submission. Already number is already,
that you have to tell them that
But without-
it is.
so already the number is given before the office. But he was not taken complaints office objection without coming before this court.
No,
You
if
write-
office raises an objection with regard to maintainability, then what is you should say, you should write on that, saying that it is maintainable for submission before the court, it should be placed. You
Yes,
should
ma'am.
write it,
Yes.
then it will come. Yes.
Vacating stay.
Which year?
2023. Even if
23, when was the stay granted?
it is granted in the date.
Yes, must be in 2023. Pose this matter on 18th of September. Yes.
My lord, in this matter, in respect of item number 1, my lord, we can put as matter,
Item number 1.
madam, my lord. 2018 pendency matter, my lord, this is now between the defendant and developers, my lord, there is a partnership deed is entered, my lord. Now they are
MFA is of which year?
2018, my lord.
Pose this matter on 12th of September.
And
Yes.
they are
No, it won't be, not before that.
developing the property, my
Not
lord. They have-
before
they have
that.
filed the memo.
Not before that. Yes,
Madam, MFA, this, my lord,
Not maybe-
yes.
MFA, year of,
It's a short date than that.
The tendency of the suit, my lord, they entered partnership deed, my lord, on the basis of partnership deed, my lord, they are.
Anything is,
developing-
everything
developing
is,
the property
everything is
Fine.
pendant.
without
Whatever
allotting my
happens,
share,
it's a
my
pendant like
Right.
transactions.
lord.
Yes.
Without allotting my share, my lord, including my
Court
share
has,
also, they are
court has
develop-
lot of matters to do. It cannot. Please
including my
understand.
share also, they are developing.
Let it be,
That's
let
fine.
it be. Yes.
MFA, it's an LAC matter of the year.
standing.
2022, my lords.
They are cut-
Warrant has been issued.
1 minute, let her complete.
My lord.
Whatever she wants to say, let her say. Yes.
My lord, there are already cut and removed the standing trees, my lord. Now they are developing a property, my lord. Instead of allotting my share, my lord. During the pendency of the suit, my lord, just April, my lord.
Yes. September 12th, yes.
That's
Fifth,
MFA.
sixth.
Then we'll have it end of October. Shall we? Please
Leave
understand.
it to the court.
Yes.
MFA, my lords, LAC matter of year 2022. Warrant has been issued, man. Kindly have it on Tuesday.
Tuesday. Yes.
That's it. I have filed memo for withdrawal.
Hmm.
List to serial number 3,
You-
madam.
Which one?
List to serial number 3, madam.
Take it, take that. List?
List to 2, madam.
Uh,
Serial number 3.
hmm. A memo is filed stating that in view of the government order number PWD 01 EAT 2023 Bangalore dated 17/11/2003. They want to withdraw the presented petition. The memo is taken on record. The appeal is dismissed as withdrawn. Yes,
That's not.
I should have fixed the date on 18th. I'm traveling on 18th, maybe on 19th.
19,
Please.
that one. Yes,
My lord, sir, the pending matter, my lord, I'm filed an application for vacating the status order passed by this honorable court. My lord, the suit schedule property is a village road, my lord. Now,
no, not necessary. All those facts are not necessary. When is the order granted by this court?
order was granted on 20th of November 2023, my lord.
Yes, pose this matter on 19th of September.
Because of monsoons,
We'll see, we'll see.
My lord, I am
There's
for the
only-
respondent, my lord.
Yes,
We have filed for the stay of vacate, my lord, but this honorable has given this stay on 2022, my lord.
all the more reason that it should be heard at a later point of time. Take that, pose this matter on 18th of September.
Obliged, my lord.
the fresh matter, my lord, this is a suit.
Fresh matter, office
objections have been
objections,
complied.
they will list it. When was the office objections complied with?
About 3-4 days ago, my lord. The urgency.
Take it. No, the problem is everybody is giving the slips down, the registry is coming up saying that these are the objections.
No,
So
my lord.
don't give the slip without clearing the objections. Yes,
Serial number 21, my lord.
Page wise adjournment,
Pending, another pending matter, my lord, for admission, my lord. This is
only
regarding
one advocate, only one slip. Today you are already
proxy
made
counsel,
two.
my lord, in this matter was.
No, even proxy also only one. Yes, next.
page wise adjournment, list one, page one, serial number 1 to 6. Page two, 7 to 11. Page three, 12 to 20.
Yes, 21.
21, ma'am. I have memo for withdrawal, ma'am.
Yes. A memo is filed stating that the dispute between the petition and the respondent has been settled in MC number 93 of 2024. And as per para 8 of the judgment dated 24/6/2024, the petitioner will not claim any maintenance or permanent alimony from petitioner number 2. In view of the same, the petitioner wants to withdraw this RPFC. The memo is taken on record and the RPFC is dismissed as withdrawn. Yes,
Page
My
number,
lord, serial number 18.
serial number 18.
18, my lord, causeless one. Kindly have it on Monday, my lord. Senior is out of town. There's a personal inconvenience.
Yes, at the request of Land Council for the appellant poses matter on 9th of September.
Dateful, madam.
Yes,
page number 5, serial number 27 to 30.
29, Your Honor.
Hmm.
Maybe Monday it may be posted.
have you informed the other side?
Yeah, yes.
Why is it, what is it, why it is coming up?
That is for impleading application and also hearing on IA for stay.
Be done.
So that
Notice has to be ordered.
another colleague is engaged in this case. He has to.
Nothing to argue now. We'll just look at it and pass orders. No adjournment required in this. Yes, don't make any mentions in interrogatory matters.
Well, Monday, Your Honor.
No.
You can stay also, we have to argue on that. So
You argue on the stay later. Implead petitions and all, wherever IS can be ordered or IS notice can be ordered, it can be done. Why unnecessarily we adjourn the matter? No orders will be passed by the court adverse to your interest now.
because I have no instruction, but yes.
Don't worry. Yes.
Page number,
my lord.
20?
27, my lord.
Ah.
Well, after Monday, my lord, senior is suffering for some viral fever, my lord.
Have you informed the other side?
Yes, yes, we'll inform.
A 2019 matter and it's in dismissal.
Well, after Monday, my lord. Ready, ready.
In the same caption, at the request of land counsel for the petitioner, or post on Monday, it is submitted that they've informed the other side. Yes.
Page number 6, cell number 31 to 33, page 7, 34 to 37, page 8, 38 to 41,
Yes. All the list.
page 1, cell number 1,
For interrupting, my lords, I have submitted a memo. Can it be had after 22nd, my lord? Senior will not be out down on 19.
Well, what is the date given?
19. It's MF
22nd, post on 22nd, that memo. Check it, check that memo, which is that, which is yours.
034 of 2024.
Yes.
Please, ma'am.
page 1, preliminary hearing, cell number 1,
Lord, this petition,
Shetty K for petitioner.
Yes.
this petition filed by a petitioner wife, my lord, challenging the order passed in IA under order 24, section 24, in the divorce petition filed by the husband, my lord.
You want enhancement?
Enhancement in the sense I have been not benefited
Granted.
by the order, my lord, because there is one DV
Then take notice. Petition is permitted to take out notice on the council appearing before. the
emergent
trial
notice, ma'am.
For the respondent.
Emergent notice.
You can take hand summons.
Yes, ma'am.
The petition is permitted to take out hand summons on the council appearing for the respondent before the trial court and file a memo to that effect. If the memo is filed by 13th of September, post this matter on 24th September. Yes.
Cell number 2, Revana Siddappa
For the petitioner,
for
my lord,
petitioner.
the petitioner counsel is not well in eye operation.
When do you want?
Hence, next week. my lord.
As a request, land counsel for the petitioner, post this matter on 12th of September. Yes, next.
3, Prasanna Kumar,
The petitioner, my lord.
RS.
So this petition is against the orders passed by the family
Govind
court
Raj.
on the interim application in the petition under section 125 of the
How much is
See-
granted?
20,000, my lord.
You are for the husband.
Husband as well as son, my lord. Husband, but the so-called husband is the adopted father of the son. The fatherhood is unknown to the son, my lord. The mother has given the son in adoption to the petitioner number 1. Petitioner number 2 is the son. Lord,
So please come to the cause title.
please.
What is this? Petitioner, the wife had filed the petition.
Please, my lord.
Then who are the respondents?
Respondent number 1 is the the respondent number,
Looking at page number 24.
please.
Yes.
Respondent number 1 is the husband. The wife is claiming as so. my lord.
According to you, she is not your.
No, my lord. There is no marriage, but there is no relationship of
Then who
marriage.
is number 2?
Number 2 is the adopted son of the respondent number 1, given by adoption was given by the petitioner. Please, my lord. There is no relationship of husband and wife. So for the years 36 years, the son is old now. There is no relationship of husband and wife. Once the adoption was given by the respondent herein.
How are you related to that lady that she gave her son in adoption to you?
Lord, she approached the petitioner herein, the petitioner number 1. He was a government servant. He was working in a BBMP. And during those days, Lord, she has left her husband and has came to
You have adopted this second respondent.
during 1989, Lord.
Let's, please come to the finding. of
Impugned
the-
order, Lord, I'll take your lordship. Impugned order, Lord, starts at page number 24. The reasons I will take, Lord, I'll take your
But
lordship.
you heard there was a marriage was performed on.
That has been
59.
claimed, that has been claimed by the wife, as if the marriage has been performed and this thing. And simply, my lord, I'll take your lordship, one of the document, Lord, see. The manipulation of the document, how it has been done, the birth certificate. On the basis of the birth certificate, my lord, the lower court has granted the interim order. I'll take your lordship, may kindly be seen, Lord. Page number 13 may kindly come to me. Lord. Page number 13 is the birth certificate. my lord, the name of the mother,
Mother, where do you, yes,
Uh,
mother.
column-
D.H. Lakshmi,
fifth item, my lord, fifth,
D.H.
sixth,
Lakshmi.
D.S. Lakshmi, name of the father,
Hmm.
Hanumanti Gowda, who is the petitioner number 1 herein. The my lord, the birth certificate, the birth of the date of birth of the petitioner number 2 is as on 1987. That certificate issued, my lord, is in the bottom of the page, my lord. Date of issuance of the birth certificate 29/7/2022.
Maybe a copy of it is not there. They
No,
might
no,
have
my
applied
lord,
for
I'll
it.
take your, the previous page, I'll take, my lord. Previous page, my lord. The birth of the son, 14/8/1987.
Hmm.
Registration 17/8/1987. Wherein, my lord, the father's name has not taken place. It is not finding place in that certificate.
Name of it is father or or
Mother is
mother?
there, mother is there, it is an undisputed fact.
Hmm.
Father's,
Then how can they issue a birth certificate like this? Well, it's issued by a
no,
competent
my lord,
authority.
see, once the mother, a pregnant woman come to the hospital, my lord, the registration will be done in the hospital and the information will be sent to the register of births and
When is
deaths.
it registered? You will see, you will find
It is-
here. When is it registered?
It is registered in as an 87 itself, my lord, 17/8, after 3 days of
Look
the,
at the date of registration. Where is that?
parallel to date of birth, my lord, on the left hand side, date of birth, it is there, parallel to that, my lord, right hand side,
Hmm.
registration of the birth. After 3 days, it has been registered.
Date of registration is?
Please, my lord.
29/7.
No, 17/8/87, my lord.
17/8.
17/8/87.
Hmm.
Issuance of the copy and no, for having accepted the fees, my lord, 88. This copy, without finding place of the father's name, it was issued in the year 88. Till 2022, the certificate remained. Without the father, the certificate has been continued. 2022, for purposes of filing this petition, my lord, she has seen that the name of the father
Is there
is,
any adoption deed?
adoption deed is not there, my lord. Adoption deed is not there. See, there is no element of at least having lived together even a single day. There is no proof of document. And at least if at all there were to be a marriage, my lord, at least bearing a
When is this MC filed in 2022?
2022, my lord.
According to her, how was she maintaining herself before that?
Through the husband, my lord, she has another son by name Vijay Kumar. He is maintaining her. And in addition to that, the second petitioner, my lord, on humanitarian grounds, he was also paying some amount, 5,000 rupees per month. The proof has been produced by the mother. And my lord, the legal notice as issued by the wife, my lord, I'll take your lordship. Legal notice, the prayer in the legal notice, the demand in the legal notice may kindly come to page number 43, my lord. She is not demanding any status of wife or status of the family or
What is the
anything.
income of the second respondent?
Second respondent is earning around 1 lakh rupees. He is into a software field. He is earning around 1 lakh rupees, my lord. And the first petitioner, my lord, is a retired engineer from the BBMP. He is earning only about 28,000 rupees as pension, my lord. As far as the son, my lord, he can shoulder some responsibility to take care of the mother, my lord. There is no dispute in that.
Now, what is the order? Ultimately, whose responsibility is it?
Both, against both, my lord, it has been awarded 20,000 rupees.
You are referring only for the father.
Both of them, my lord. Both of them.
So now the other will pay.
My lord,
Now the second respondent will pay.
will pay some amount, my lord.
Why some amount? Why he's he's earning 1 lakh. What
No,
will-
he has his own family, wife and the son, daughter, my lord. And he has
When you let second respondent paid, second petitioner
second petition.
pay 10,000. And when was the petition filed?
That is also exorbitant, my lord. Why? Because he has his own
We
responsibility.
will see once the
So
other side,
loan liability and all is there, my lord. Under
once the other side comes. 16-4, when is the petition filed? Seeking maintenance,
application.
IA,
August 22, my lord.
August 22. That's 2 years, almost, 24 months. Please come. Glen Council. No, not very good. Agreed with the order of maintenance granted with the trial court at 20,000 per month to the respondent hearing. The petitioners are before the court. The first petitioner is the father, second petitioner, is, second petitioner is the son. It is a case of the petitioner hearing that the petitioner, he has no relationship with the respondent. He had adopted the son of the first respondent. And it is submitted that the respondent herein has placed the birth certificate before the trial court. And basing on that, she tried to prove that the petitioner herein is her husband. Then counsel submits that the birth certificate was registered. The birth was registered on 17/8/87. In that certificate, which was issued on 29/2/88.
17/8/88.
No. Date of
Yes, please, my lord. 88.
29/2/88. The father's name is not shown. Before filing this petition, she had obtained a copy on 29/7/2022. In that, the father's name is shown as D. Hanumanta Gowda. That is the first petitioner. Learned counsel submits that the said document is a fabricated document and without any basis. The application is filed seeking maintenance on the trial court without considering all these issues and held that both the petitioner number 1 and petitioner number 2 are liable to pay the maintenance. He submits that when it comes to the second petitioner, who is the son of the respondent herein, his salary per month is 1 lakh. He has to take care of his wife, child, and also he has to
Old father.
pay,
also.
yes, certain other commitments where he has to pay the EMI and other loans. He submits that the amount of 20,000 that is granted is on the higher side. The first petitioner is a retired employee of BBMP.
Yes, please.
And his salary is pension is drawing pension of an amount of rupees 23,000.
28,000.
28,000. He submits to the trial court without considering any of these aspects and granted the maintenance and maintenance. This court has perused the certificate that is placed before the court. And the stand that is taken by the first petitioner. During the pendency of this petition, the considered opinion of this court, the first petitioner need not pay the maintenance. Then coming to the second petitioner, there is no dispute that he is the son of the first respondent, considering that he is earning an amount of rupees 1 lakh as salary. As an interim measure, there shall be stay of all further proceedings on the condition that the second petitioner shall pay an amount of rupees 10,000, the 5th of every succeeding month, and towards arrears for 24 months, an amount of rupees 2,40,000 shall be paid within 8 weeks from the date of receipt of the copy of the order. Same default order, either of the two.
May I request your lordship to add a sentence, my lord? Because once the adoption is given, my lord, even the adopted son against the natural mother
He
is not.
submits that and council submits that once the second petitioner is adopted, he has no connection with the natural
Please,
parents. Parents, and he has also no obligation
please.
to maintain, to pay the maintenance. Same, and the petition is permitted to take out notice on the council appearing before the trial court. It shall file a memo to that effect by 80 hand summons, notice.
12 weeks may kindly be granted. 12 weeks may kindly.
12 weeks. By 18th of September, pose this matter on 1st of October. Yes.
Obliged.
Sale number 4, Nataraj BS for petitioner, Arun Govind Raj for respondent.
In this matter, lordship.
Request a copy to be served upon.
Because no notice was ordered because they defied Wakalat when I have made a submission before the trial court by filing the petitions. I have no objections. I will furnish it. No issue at all.
Tomorrow we'll.
Reason is that, my lordship.
Tomorrow we will have it.
Much.
If I may request.
The-
He is unavailable. Anytime in the coming.
Because the
He must
trial
have
court has the
submitted.
trial court has passed the conditional order that only one opportunity has been given, otherwise they'll proceed with the matter. Till then.
On 10th of September before the trial court, your knowledge. Anytime before that, subject to the convenience of this.
We'll have it on 9th September. Before the matter comes up before the trial
Fourth.
court.
Fourth, it may be listed, my lordship.
So on 10th of September, your lordship, I just verified.
What is the difficulty on 4th?
I have no objection on.
4th, pose this matter at the request of the counsel for the respondent on 4th. The counsel from the petitioner shall serve the copy of the writ petition on the council. Yes, Nick.
Sale number 5, T. Balakrishna Shastri for petitioner.
On the petitioner. Divorce petition, my lords. Petitioner is the respondent in the divorce petition. An application under section 24 of the Hindu Marriage Act was
How
filed.
much is granted?
My lords,
How much is-
5,000 was granted, my lords. We had claimed 15,000 monthly expenses.
Go for the wife.
For the wife.
The same hand summons by 20 on the council appearing for the respondent, memo to that effect by 25th of September. Pose this matter on 30th of September. Yes.
Sale number 6, Chandranath Tariga.
Here for the petitioner. My lord, a compromise was brought in between the petitioner and the respondent. What was agreed was 41 lakhs to be paid to her. Apart from that, half the value of the apartment which they together own. What is now in the compromise, she finds that it is only referred 41 lakhs. The half of the value of the apartment is left out. Therefore, she has prepared this petition. The compromise petition, it is in the order sheet only at page 46.
What is included now before this court?
That very same order, the order
No,
passed
when-
before the Lok Adalat. The Lok Adalat records that only 41 lakhs the petitioner has agreed. That is not what she had agreed. Half of the value of
All
the,
in Kannada.
no, it is in English.
Where is that?
Page 46 is the order sheet. 9/9/2023. Respondent agreed to pay rupees 41 lakhs towards full and final settlement towards maintenance of the petitioner. Petitioner agreed to above settlement to receive the amount towards full and final settlement. Agreed to withdraw all the proceedings. And petitioner also agreed to give consent for dissolution of marriage in the petition. And that is recorded, whereas regarding the apartment, half the value of the apartment, that is not, the award is not drawn. My lord, even on this, award is not drawn. It is only in the order sheet. Based on this, the respondent has now proceeding with the criminal prosecution. I have stated so. He has filed the criminal petition. Criminal misl at annexure F, my lord. Fine levy is ordered. He says direct the petitioner to receive the 41 lakhs in terms of the Lok Adalat award. order, award is not passed. Award need to be passed.
No, there won't be any, before passing an award like this, the party signatures won't be obtained.
So a party signature on the order sheet is obtained. There is no,
You must have gone through that.
yes, ma'am.
You must have gone through what has been there in the order.
My lord, she was promised half of the value. That is
your
not
counsel is
reflected.
there,
No,
counsel
that
is
is,
there,
that is, that-
petitioner is there. So both of you have gone through what is there in that, then you will sign on that.
the counsel who is appearing for the party is not appearing now at all. She makes a request. He sent 11 lakhs. The petitioner sent it back. This is not the amount.
Oh, look at it, page number 47.
Please.
There are signatures of
So-
the advocate.
Yes, ma'am. Respondent agreed to pay the maintenance, agreed by him within 3
No, no, no,
months.
no. At page 40.
Signatures, yes, yes, ma'am.
Then-
Signature. My lord, this is what was promised is 41 lakhs.
Why did you sign then?
My lord, she says her lawyer asked her to sign and she signed and the lawyer is not
What happens
responding.
if there is no end to the litigation? Why do you appear before the Lok Adalat? Why do you sign? And after coming here, now again you
And
question it saying that, no, how will the court understand that what has been transpired between the parties is something else, but not this?
My lord, it should be followed up with the award. Award is not passed. Award is not passed.
That is a different aspect.
No, that is,
That's a
that
different
is
aspect.
continu-
If it is not,
continuation
if
of
it is
this.
not, it will be passed. No,
No,
the issue
so far,
is,
my lord, this.
according to you, you agreed upon on something. Where from the court
My
should
lord,
understand?
according to the petitioner, she had not agreed. She had agreed to receive these 41 lakhs in cash and also half the value of the apartment which they jointly own. And kindly see this annexure F. Immediately he files a criminal miss seeking a direction that the order should be implemented. Amount is taken back. First installment, he sends it belatedly. That is taken back. That amount is, he has taken back 11 lakhs. And then issues this, files this petition.
No, by virtue of this compromise, he has to pay you so and so money.
Yes, that is not paid.
If it is not paid, then what should be done?
No, my grievance of the petitioner is not only that, my lord. If that is not paid, there are methods by which you can.
Yes.
But what was agreed between,
From the court has to infer,
my lord,
that is the question.
my lord, she goes to the extent of filing an affidavit that this was not, because
But she can, when she can sign like this, before that's not, no, if everybody after the settlement is done, comes to the court saying that my advocate has asked to sign, that's why I've signed. How is it? There is no end to the litigation at all.
my lord, she can, my lord, what could be done is only an additional affidavit other than that, because this lady who is a student, he says that this was not, what was
It's the educated person.
educated person, not that she is
Should
pursuing
respect
her studies now alone. He is pursuing her studies. He is-
No, after any order is passed, no, she'll say, this advocate has asked you to do it. Now they'll go to the Supreme Court. No, that's not the way.
Hmm?
At least there should be something to, at
My
least
lord-
the court to be convinced that this is arrangement. Contrary to that arrangement, this is done.
And the
Nothing,
kindly see
just her
page-
own self-serving statement.
my lord, this, it is a.
It's
fact-
not even our case that there is misrepresentation, there is fraud. Only those are all the
No,
grounds
that,
that are. Who has committed, the
now
the
she is,
judicial member and the non-judicial member, both of them.
my lord, now the statement is,
And all those questions of,
the suppression of material facts, not a judicial members, we cannot, my lord, how can?
no, but ultimately before him, you signed and
These,
but they have said so.
Unfair compromise by suppression of facts, because even now, the apartment stands in the name of both of them. That there need to be a release deed, that has not been done. And kindly see page the 52, award of Lok Adalat. Award has not been passed.
Five.
Section 21.
Award is not passed, award will be passed.
My lord, 2023, my lord. It's only
But
an
we will
order.
find out why it is not, but you have to convince the court that it was so and so. And the order is something else. For that, there should be something. You signed it, you do not deny that it is your signature. You say that my advocate asked me to sign, I signed.
My lord,
When you have to read the contents before an order is passed. Now, once this kind of an application is allowed, from tomorrow, everybody will come to the court that signature is mine because my advocate
lord,
asked, I signed.
my lord, what was agreed, what she could say before this honorable court at paragraph 18 is she says that the respondent has taken advantage of the fact that the petitioner was not well versed with the legal technicality and consequences of the terms
There are
of
no
the.
legal technicalities in this simple point. What is agreed upon? You want money, you want so and so. Those are the two simple issues. No other, that I think anybody can, even any layman can understand that.
And there was a misrepresentation of her share of the property over which she has a right, which was agreed and was not incorporated. This is what she has said. Only for, yes.
Let notice go, this is not a case. And
But
I think,
now, my lord, kindly see this page F, my lord, wherein he
not
has got,
say anything with this kind of petition. Pose this matter, where the petitioner is permitted to take out hand summons, so and so. Pose this
my lord,
matter
hand
on-
summons, he is not, they are not in good terms, my lord.
To
He,
the advocate,
counsel.
to the
Yes.
counsel, appearing before the trial court. And file a memo to that effect, pose this matter on, if you can, then if you can take out by, you can file a memo by 13th, the matter, if the memo is filed with regard to service of notice by 13th, pose this matter on 18th.
18.
Yes.
Then number
Please.
7. Keepers, soccer,
If
For
the
petitioner.
petitioner, please.
For the Please.
aviator respondent.
what?
I've served my learned friend the petition copy.
Yes.
Lords, the petitioner is before your lordships. Questioning the order dated 13/8/2024, passed on IA number 10, granting interim custody of the minor child Master Ahan to the respondent, please. What has happened, please, your honors, my lords, is that a petition for divorce was filed by the petitioner.
Where is
In-
the impugned order?
Impugned order, my lords, is annexure E. Here is a case where the matter was closed by compromise. My lords, may kindly see, on 30th of November 2020, the parties entered into a compromise before the
What is the date of compromise?
30th of November 2020, my lords. That compromise is at annexure A, page 38,
38.
page 38.
Hmm.
In this compromise, they agree that their marriage will be dissolved. Permanent alimony of some money is given. 2 other cases filed by the wife, GNWC and criminal miscellaneous, are agreed to be withdrawn. There are 2 minor children. At that time, the boy is aged 11, the girl is aged 8. They agree for joint custody and the term that, my lords, may kindly see page 39, please, my lady.
Yes.
Clause 9. The parties have agreed that both of them shall continue as guardians and joint custodians of the 2 minor children. The children will live with the petitioner father for 15 days and with the respondent mother for 15 days every month. Financial arrangements are that both of them will jointly share.
Oh, a compromise decree is passed.
Is passed, my
Where
lords.
is that?
That is this only, a continuation of this, my lord.
Hmm.
Page 44 onwards.
This is passed when?
Same, 30th of, it is dated 30th of November 2020, my lady.
Then what happened?
Then what happens, my lady? This arrangement continues quite well. Then in around June 2022, some difference of opinion between the petitioner and respondent. When the children are with the mother, they are not sent to the father's house for some time. Then this happens again in February of 2023. For 2.5 months, the children are not sent to the father. And this boy, he has autism.
Another boy and a girl.
Boy and a girl.
What is the age as of now?
Now the boy is 15 years old. The girl is 12.
Hmm.
Now this, what happens is, my lord, that in around February, when both the children are with the mother, the children are not sent to the father in accordance with this compromise. This has happened once before also. The boy suffers from an autism spectrum disorder, which is a borderline case. It is not that it is a severe case, but he has some impairment, he has some learning disability. And there is a report that I will take my lady through, that there is some understanding of some educational concepts is though, which requires training and treatment is what the Spastic Society has said. So when when he is not sent, he is completely cut off from the father and father's family. Father's parents live with him. Subsequent to this divorce, father marries again. That lady has a 13-year-old child who lives together. So both these children and that child have gelled well. And while in this February and March of 2020,
Mother is not remarried.
Mal-
Mother has not married again.
no, mother is not. She had another relationship with another person who was living in that relationship broke away. But nonetheless, I have no dispute or qualms with that. In fact, I have stated or note to say that over a period of time, I became comfortable with that gentleman, and he used to come and pick up and drop the child from my children from my house and take them back. I have no, but I mean, that relationship does not survive anymore. Now, what has happened in that time, this boy is a district and state level cyclist. He undergoes physical training, coaching regularly, and so on. So on 19th of March 2023, all the family members, both the parents as well as grandparents, everybody go for this race. There is some incident that happens, and the son wishes to come with the father, but that does not.
What happened?
The son, because he has been deprived from going to the father's house for about 2 months, he says, I want to come home with you. But something does not work out, but he still goes back with the mother. Then on 2nd of April 2023, after a training session, where father goes to visit him and see him train, etc. Mother is there, daughter is there. The son simply says, he just gets into the father's car and says, I want to come back home with you. Since then, he is with the father. And despite, I am instructed to state that despite.
What is that? From which is the date?
That is on 22nd of April 2023.
So, and now if he continues to be with you means contrary to the terms.
It is contrary to the original terms of the compromise. I do agree. But then there is sufficient material where the boy has said, I do not want to go. He speaks to her regularly. Then this happened in April. I agree. Then in May of 2023, an application is filed, IA number 9 under section 38 of the Special Marriages Act 12, etc., seeking to vary the compromise insofar as the custody is concerned and to grant permanent custody of the children to the mother. Mother files that application in May. That is on 31st of May 2023, IA is filed. Then subsequently on 4th of July, IA number 10 is filed to say, while you are considering that in pending disposal, grant me interim custody of the son. Now that is an order has been passed on that application, which for which
Interim custody means, please come to the operative portion.
kindly, my lords, kindly see annexure E. Order starts at page 78.
78.
And the operative portion is page 89.
The 78.
The order commences from 78. Operative portion is in at page 89. IA number 10 under section 38 of the Special Marriages Act, read with section 12 of the Guardians of Wards Act, and section 151 CPC is allowed. Petitioner is directed to hand over interim custody of the autistic child, Master Ahan Saran, to the respondent forthwith till further orders. Petitioner is entitled to visitation rights of his minor son Ahan Saran on every Sunday between 10 AM and 5 PM at the house of the respondent on prior intimation. Petitioner is entitled to video call facilities once in 3 days. Respondent directed. This is
So what was the reason for the court to alter the
that is
arrangements?
my humble submission is that there is no cogent reason at all. There are some legal issues which I may bring for a lot ladies' kind attention. Now this matter has been disposed of under Order 23, Rule 3, read with section 89 and section 10 of the Family Courts Act.
No, as far as the child custody is concerned, It all
I agree.
depends upon the
I agree.
requirement and changed
I agree.
circumstances.
Now, there has to be some formal order recalling that earlier order relating to the compromise. That order has not been passed.
No, why can't the earlier arrangement go on? He has violated it. There is no dispute on that. No, why can't, as per the earlier arrangement, 15 days here and 15 days with the mother?
Yes, my lord. What is to be
The
noted,
court also observes that the boy is attached to the father. Why only visitation?
I'll come to that. There is no dispute that the father loves the child. We are not disputing that. There is no dispute that the child loves the mother and the father. We are not disputing that. Mother loves the child by being birth mother, and she is trained how to handle autistic children. She knows how to do. My lord, the compromise happened on 30/11/2020, as rightly stated by my friend. This was during peak COVID time.
Yes.
At that point of time, my lord, visitations, etc. are not happening. Lockdowns everywhere. It was all in different places. People were not even aware when these lockdowns will go out, what will be life after. So during that time, people were all working from home. My lord, at that particular point of time, the father also was working. He's a very senior executive in a particular company, and he's very prone to travel. His job requires. Mother is also a very senior executive, my lord. She's a PhD holder. She's also well educated, well settled. There is no money requirements between either of these people. Money is not an issue for both of them. It is only relating to the welfare of the child as contemplated by the mother or the father. It is different parenting styles. 15 days used to work when the COVID was going on. Because the child was with the father and the father was able to give 100% attention to the child. Subsequent to the lifting of the lockdowns, subsequent to the reopening of the borders and all, and when the father started working again full time, during the time when the child was with the father, the mother requested, if you are traveling out of country, used to travel, at that point of time, you drop the child home. We will look after the children. Once you come back, I will give it, because the father's family also loves the child. We have no doubt on that part. But loving a child is different from taking care of an autistic child in the way it is supposed to be taken care of. My lord, the Disabilities Act passed in 2016 very clearly puts autism as a specified disability. The intent of the act is to make the disabled persons or persons with disability independent. My lord, the idea is to make this child independent and to be self-sufficient in his life. We never know, my lord, who will be alive for how long. The child has to learn how to live on his own. The parenting style, my lord, of the father and mother is of 180 degrees separate. Mother demonstrates tough love and tries to make the child independent and self-sufficient. For example, if the child feels thirsty, mother will not get up and go give him a glass of water. She will say, if you feel thirsty, go get your water. So he should learn how to express the feeling of thirsty. I feel thirsty, I want water. Whereas the father, 4 people will come with glasses. It is not that the question of love, it's just the parenting styles that are different. My lord, the concept of an autistic child is very different from a regular child. If the child was not autistic and 15 years, my lord, the Guardians and Wards Act and even the would come into the place where the child's opinion would be considered intelligent preference and the child's opinions will be honored and respected. Though the act says, even if the child prefers, the court may pass orders appropriately. In this case, my lord, the child does not have an intelligent preference. He is being tutored. While the father has retained on the child on 2/4, he has retained so, my lord, after assaulting the mother in public and then taking the child away. Those facts have been suppressed in the petition. I have gone through, my lord, every line has a lie in it. If I need to address properly with filing proper objections to this.
No,
For that purpose, my lord, anytime lordship feels.
We will not go into all those
But the
issues.
point here is, my lord, the 15 days is not working because of changed circumstances. subsequent.
If it is not working, we have to see how it works.
Correct, my lord. Kindly see, my lord, page number 108 of the petition itself.
Yes.
The changed circumstances are mentioned very clearly in this, my lord. Why the mother has preferred an application under section 38
That-
and of the Special Marriage Act, my lord.
No, one issue that you put forth is with regard to the constant travel of the father.
Correct, my lord. First, my lord, is that is changed
There is no
circumstances
constant
are.
travel, my lord.
One minute, we'll come to. Constant travel is
Yes.
one. And the second thing you're saying is about the different parenting.
Yes, ma'am. Kindly see the page number 108. I've listed it in 4 sequential orders.
Yes.
First one, my lord, is the remarriage of the petitioner. Petitioner has now a new wife and a child from the first marriage. So he is occupied in taking good care of them and whatever. And then because of the fact that
It is not
that is
against
one,
that.
that is
No, no.
one part.
It
This
is
brought
not,
in.
no, no,
cha-
no, that cannot, we cannot consider that because you yourself are saying that the entire family lost the boy. They're taking care of him. So the second marriage cannot be a ground for the. It
I
can't be a change
I
circumstance.
will explain why it is, ma'am. By per se, it should not be, ma'am. Per se, a second marriage or a third marriage should not be a ground, ma'am. But if that marriage interferes in the upbringing of the child or the arrangements understood by the both the parties and agreed to
So if the
between both the parties.
mother contracts a second marriage, what should happen then?
Which, my lord, that was also, my lord, whatever at that particular point of time, all custody orders as per Supreme Court, my lord, Rosie Jacob, are all interlocutory orders. The father also will have a same right in case
Yeah, but it
they have to
can't
do
keep
it.
That's
changing
why-
every time situations
That's
change. my
why
lord.
we have to look at the holistic.
Absolutely,
picture.
my lord. So whatever were happening
No, we are
properly.
looking, forgetting, just forget about what the mother and the father, their feelings are. No, as far as the boy is concerned, as you have rightly said, because he's a specially challenged
Correct,
child,
my lord.
he need to live his life independently and one has to train him in that way. So for that, what the father has to do, what the mother has to do,
Correct, my lord.
those are the issues.
That has been agreed, my lord.
Ah,
But
so-
not followed by the, kindly see the.
No, that's what we will do is that now a solution to a problem is just not going away from it.
Absolutely, my lord.
Yes.
We have requested.
No, that's what we will do. Now let this writ petition be pending for some time. Now let the arrangement, how it was earlier, as per the compromise, should go on. We'll see how it is, why it is not working out.
My lord, may I?
The-
Yes.
Basically, my lord, the reason why that 15 days failed, kindly see para number 3, my lord,
Hmm.
of 108.
Hmm.
Page number 108, para number 3. Lordship
Oh.
will understand why we are saying it was not
Yes,
working.
yes.
Kindly see. The parties also agreed that due to their elder son Ahan's autism, both parties will agree to cooperate on a single parenting style that will work for the child, irrespective of where or with whom the child is. This is very critical for the children with autism so that they have a good and proper functional lifestyle. Unfortunately, this was not adhered to by the
We
petitioner.
understand, whatever your submission, I understood.
Yes, ma'am.
That you want to bring him up in a way where he can be.
Yes, my
He
lord.
can take care of himself with
Correct.
all that difficulties or whatever he's having. And the father is
The
doing it
father
in a
is
different
also
way.
interested
No,
in that.
no,
my lord.
no, please come up with some material before the court, how it should be. Like how he should be taken care of from morning to night. What or is, because you say that you are an expert in dealing with that
My lord,
specially challenged
we have
children.
done that, my lord. Unfortunately, the father says, when the children are with me, I will do what I want.
as
My lord, he has gone on record to say this. I will do what I
That
want.
is-
He
When the
cannot
children
do.
are with you, you do what you
No,
want.
Question of
he is
evidence,
Don't tell
my lord, I
me
don't
what I
think
am
this can
supposed
be
to do.
argued
Please
like this.
please understand, no, he can't afford to tell all that.
He said, my lord, what
He
can,
might
I am
have- he
reporting
might-
the facts here to this honorable.
He might have said, but now the court is saying, no, it is not a fighting at all between the
Absolutely.
parents.
My lord,
Let us look at the interest of the child. He is very much attached to the father as also to the
I'll
mother.
come to that.
No, let both the mother and father realize and do things which are good for the child. Please tell the father what is to be done. If you say so that you have already said, if it is there anything on record, we'll record it and say, just, no, we'll give him one more opportunity, whether it is working out or not.
May I make?
In fact,
may I-
it is
may
the
I make
other
some
way
sub-
around, according to me, please, my lord.
May I make some submission? From the time this application was filed in July 2023, till the time this order was passed on 13/8, 28 hearings happened in the family court. Two judges have seen this case very closely, my lord. After hearing the matters extensively, each hearing, my lord, going for about a 45-minute to 1 hour, going through reams and reams of papers, citations, this order was passed, my lord, after speaking to the children in chambers for 2 times. The family court, my lord, has applied its mind very, very judicially and came to the conclusion that this is the best arrangement. And my lord, the reason, one more reason is, on 3/11/2023, my learned friend has not produced the order sheets before the trial court. May please the court, my lord?
Why is it that you do not want
On
to?
3/11, my lord.
No, you don't, you want that order to be retained, you don't
No,
want to
ma'am.
give a chance.
No, chances are given, my lord, and badly misused. More importantly, my lord, the child has been suffering. He has now got a physical condition called scoliosis, my lord, where the spine turns. He is to be taken special care of.
What did the father contributed to that?
My lord, the father contribution is, my lord, there are cycling competitions that will go on, my lord. There are 2 types of cycling competitions. So one is, my lord, MTB, it is called, mountain terrace biking, and one, my lord, is on the road racing, my lord. The child is admittedly a child with learning disabilities. Kindly see, my lord, page number.
Yes, we'll take that,
Yes.
yes.
It's a learning disabilities, my lord. He is of low comprehension. Conceptual understanding is very less. He is used to road. He cannot make quick decisions. On the road, my lord, if you are taking a child and he has to cycle at speeds of 57, 58 kilometers per hour, in that speed on the main roads of the Bangalore city or outskirts, my lord, that is extremely dangerous. How it happened, we do not know. There is a 17-degree curvature of that. And that, my lord, has to be done. There is a separate physiotherapy, etc., that needs to be done for the child.
Father can't do that.
That
My
is
lord,
being done.
father cannot do
That is
personally.
being
He'll
done.
throw money and make people do it. In this case, mother will physically be there and do it.
She has to
She can
work
work
also.
from home. She can contribute
My learned
everything.
friend is letting in evidence in this matter.
My lord, end of the day, if they are misleading this honorable court, it is my duty to answer the questions. Such comments should not be made on councils. I'm assisting this honorable court.
Yes.
My lord, the fact is, the child needs love and affection of both parents is what is constantly repeated in this writ petition, my lord, in the averments. But my lord, the father has deprived the mother of even weekend custodies, my lord, which were ordered by the court, for which a contempt petition is filed and pending.
That is, no, you have already initiated proceedings.
Yes, my lord.
And if it is, as he admits, and he has violated that compromise decree, he will face the consequences.
Compromise decree, my lord. We are not on the compromise decree. We are on the orders passed by the learned family court for passing interim arrangements were made, where every alternate week, mother has to send the daughter to the father's home, father has to send the son to the mother's home. Well, dutifully, the mother is sending the daughter. She'll go and drop. But the father doesn't bring the child. He says, son doesn't want to go. My lord, son is autistic. He is prone to tutoring. You tutor him, my lord, the mother says, if she spends half an hour, 1 hour with him, she can convince a child to go with anybody, my lord. Child is prone to tutor. So, my lord, if tutoring is done and then the father doesn't send for 1 year, he cannot take advantage of his own wrongs. And 15 day, my lord, is not working because the father is not cooperating. To the extent, my lord, is so abusive. Is so abusive towards the mother. My lord, that we had to take a protection order to see that he doesn't fall and torture the mother. A domestic violence court, my lord, has given a protection.
What is happening? Why both of you,
My lord,
you are not even concerned about a
Well-educated
child,
people, my
my lord,
concerned about a
my
child
lord,
who is challenged.
the child before the learned trial court, as well as I spoke to him, he says, I do not want to go. I will talk to her. He has been,
This
so
won't
there
work
is,
out. This won't work
Lord,
out. This
ma-
is what
the
every,
father is
what
ready.
mother is doing, that the boy doesn't want to go to the mother.
The father is ready and willing to. Yesterday, that is what happened. I told them that, see, this cannot happen. You can't leave everything to his decision, but you also have to proactively.
No, tomorrow, the boy will be with the mother for the next 15 days or 1 month. After that,
We
the
don't-
boy,
The
no,
child is
no,
already with the mother, my lord.
no,
It is
the boy,
handed over
1
to
minute,
speed.
1 minute. No, the boy is with the mother. No, the mother will tutor him and the boy will say, no, I do not want to see.
The day before yesterday,
So please
other
understand.
calls.
No, if she
say that I
says
still
that
want to
I do
come
not
back.
want to see the father,
Lord,
then the court will leave it
Lord,
like that. No,
I understand
It
the
is not for the
predicament. This is a
child.
very, very peculiar case. I do understand the predicament. But the fact remains that he is not as bad as is
Please
being made out.
understand, both of you have to adhere to the order passed by the court.
I
Everything
definitely bow
shall
down to
happen
this.
as per the order. And you cannot,
The
your
petitioner
client.
will bow
No,
down to that.
one more thing, please tell the court,
Please.
when there are several orders earlier passed by the court and your client is not obeying the orders of the court, why should there be an interference by this court?
No, but the only reason was that he has expressed very, very vehemently that he does not wish to go. It is not like I can just simply drag him and take him and drop him off and come. If it is a younger
No,
child.
when you can do it with the wife, why not with the child?
With a wife, I have not that case. What my learned friend is talking about has been closed with an NCR to say non-cognizable. That police complaint.
No,
That
my
there
lord,
is
the FIR is
that-
done, the
that
report
we
is
are-
filed, protest petition is already filed, pending for orders.
all,
Make correct submissions, God, please.
so that B report, all that has happened. There is no physical violence
There is-
insofar as
there
the
is evidence of physical violence on the
father
mother.
and mother are concerned.
The father was arrested in the US, my lord, for slapping the mother. There are records of the US courts and the US police. We have given that also. My lord, after the assault, wound certificates, etc. have been produced, my lord.
No.
Point here is, my lord,
No.
here will, whatever is the order passed, my learned friend and I yesterday had a conversation, my lord. Yes, the operative portion of the order says the petitioner has to come and see the child in the father has to come and see the child in the mother's. It is not a practical thing. So we thought we'll discuss separately and figure out what could be the terms of visitations so that the father gets the love and affection of the child regularly while the child
How
is
will
being
it,
taken
how
care
will
of
it
by
happen? How will it happen?
we will discuss it, my lord, and make it happen. It should be mutually beneficial to both the parties. And most importantly, my lord, to the child. Child must get a uniform lifestyle which is beneficial for the child. And being an autistic child, my lord, he is extremely in love with the mother and sister, my lord. He has come here home on 27th, my lord. The father refused to give, even though the order was forthwith on 13th, my lord. Till 27th, they did not, my lord. They tried to say that, my lord, to convince the child and take it. We won't have a problem. My lord, after being tutored, the child cannot be convinced in 1 minute. And they say the child doesn't want, and they hold the child.
No,
They
he
don't let the child
was
go.
forcibly taken.
But, my
Where,
lord,
Then the other day that he was forcibly.
no,
taken to the-
we've convinced him and say, you please go.
That you should have done it.
Well,
long
we-
back.
that too, my lord, because even the learned trial court, my lord, was so patient. Spent one hour every day, my lord, saying, please send the child. He refuses to send the child.
It's
Finally,
not,
my
it
lord,
is
I have to
not
file
my
an
decision to
application.
refuse.
I have
madam.
to send,
I-
I have to file an
the-
application
the
with
fa-
police assistance. madam.
The father
Only
has
then
never
the
refused.
father stopped.
Father has never refused. madam.
He
There
has
have been
refused.
repeated
Writing has
conversations.
In fact,
Again, the court will pass an order. Now, if at all, if the court is passing an order that the child shall stay with the father for 15 days. Now, again, you will say on the 16th day.
No,
that
that
the
is
boy
some-
is not interested.
No, that is
Then
exactly
you
what
cannot
has happened.
convince him what to do.
That is something that I will speak to them about this. It cannot happen like that. When the court has made an order, it is duty of every litigant before the court to follow it.
You
I
want
have
an order from the
absolutely,
court.
I have
And after once
absolutely
you
no,
obtain an order,
I
then you
have
say that it is not
I have
possible.
absolutely no qualms about saying that. But then the fact remains that
First,
this is
let him say why he has not. No,
But-
when you are
but
in the
not the
habit
only
of.
reason, the only
You are in
reason
the
is
habit
that
of violating the orders of the court.
The only
Then why
reason
should
is
the
that-
court come to your rescue and pass any order?
well, he has gone, but he has returned. But he just does not want to continue to stay there. He gets very upset. He calls and cries.
You can fight with your wife, not with.
No, I don't.
system.
I do not want to fight. I have not fought with her now in the last 3-4 years about any personal interpersonal
You're
relationship.
married, you already got married.
Fair enough.
What
but
else? They should have been there.
I
Both of you
particularly,
are highly educated.
I have my only interest is that he is brought up in an environment where
Is it your case that the wife is not doing it?
No, it is not my case.
Then-
It is not my case that she is incapable or she is, but there are certain things that have happened insofar as his education and a special educator and things like that. There have been recalls from
Which
schools.
she understands better than you. Is it also?
No, I don't say that.
Then just follow what she says.
No,
It's all in the interest of the child when she's telling you something.
he is
Follow it.
the father has already made sufficient arrangement. He goes to a school. He is under a program called
No,
Endeavor.
for example,
has taken-
if you're traveling, then why the child should not be, whether there is an order of 15 or whatever it is, when you're traveling,
See,
why the child should not be
every-
dropped
you
at the
know,
mother's
if he
place?
travels for a one day or 2 days, you know.
2 days, the 2 days with the, let the child
But
be
then
with
it
the
is their,
mother.
it is their complaint that is a back and forth does not work for us. See, every time that if he travels.
Now, if both of you come up with one.
We will try to find
one
some
complaint
solution.
or
My
the
learned
other, it
friend has
won't work
spoken to
out
me.
like that.
I agree that there has to be a solution and intervention of this honorable court
Both have
is
to understand.
necessary, but
both
we
the
have
wife
to
and
understand
husband have to
ourselves. I
understand.
completely agree. I
My
completely
suggestion
agree.
about humble situation is we can refer to mediation only because I am having more confidence in my learned friend than the party itself. We will speak to them because he has been very open. He's just come on record 2 days back, 2 weeks back. Prior council has been terminated and a new council. I feel we'll talk. We are fathers. We will try to see how we can work it
Shall
out.
refer it to the mediation?
Yes, my lord, and we will see how we can work it
Please
out.
come.
If we can send some terms which are good for
No,
both
it's
the
a high
parties.
time.
No, I agree that this has to
High
be
time, both
resolved.
the parties amicably shall settle this issue.
If they allow, my lord, we are willing to. We want the bond with the father to be there, but not like this. It cannot, every visitation cannot be.
It cannot become acrimonious.
For both the
I agree.
sides. It cannot be like that. We were forced to take the
It
protection.
should happen in a very smooth manner.
Should
No,
happen.
I completely agree. My only submission is he is a 15-year-old boy. In my humble submission, he is not so disabled and impaired so as not to understand things that are going.
Autism is something.
No, it is not. It is not
Definitely
such
he
a
is not like
severe.
a normal
My
boy.
lord, he is not a. My lord, may see the kind of prizes that he has won cycling. He has won gold medal at the
No,
district level.
autism,
No, fair enough.
that is a
That
different aspect.
understanding is there. Understanding is there in him. So my difficulty as a father is when he expresses so vehemently.
Then what about the daughter? There is no visitation for her.
Daughter goes every alternate weekend.
No, but
happily to the
this has
father.
not been happening in the last 6 months or
No,
so
no,
now.
madam. From false submission, every weekend, every alternate weekend she goes, happily spends 2 days and comes back. There is
So,
no.
No dispute on the girl.
No
No, both
dispute.
of them are fighting for this boy.
And even my lord, whenever there is a need.
That is because he came and stayed here now since like 1.5 years. That is
Shouldn't
the,
have done unnecessarily,
is-
your client has
which is-
spoiled everything.
Yes.
which
While
is
we
the
are
reason.
following, my lord, he is not following. Look at it, my
Both the councils submits that there was a compromise on 30/11/2020. As per the same, the custody of the children for 15 days with the father and 15 days with the mother. In between, some disputes with regard to this, the exercising, the disputes arose between the parties. And mother has come up with an application to change the custody of the children, seeking exclusive custody of the children. Then the trial court had passed a centrum order whereby the father is directed to hand over the interim custody of the autistic child to the mother forthwith till further orders. And the father is entitled for visitation rights of his minor son on every Sunday between 10 AM to 5 PM at the house of the respondent on prior intimation. Aggrieved thereby, the father is before this court. Both the councils have argued extensively. It is submitted that according to the father, the mother is not cooperating. According to the mother, the father is not cooperating. The fact remains is that contrary to the terms of the compromise, for some months,
No, madam, from.
Since April 2023 till 27th of August.
nearly more than 1 year, the boy was with the father, which made the mother to move this application. Both the council submits that they will, that the matter may be referred to the mediation, wherein they'll, as both the parties are interested for a compromise in the interest of the boy who is suffering with autism. Considering all these facts, the matter is referred to the Bangalore Mediation Center. The parties shall appear before the mediation center on which.
If instead of the Bangalore Mediation Center, if a senior lawyer of this honorable court can be appointed, because it may take some more time and we may be able to spend some time with them. Mrs. Sushila as well.
Mrs. Sushila, and we are very much okay, my lord. Let it happen
Mrs.
within the parameters of.
Yes, yes,
Bangalore
with
Town
it.
Center.
Mrs.
And
Sushila,
this
senior
quote as
advocate.
appointed.
Yes, correct.
She has in fact
Srimati-
done a very good thing for a couple of my kids. Very
Sri-
seen.
no, no,
very
even
seen.
Srimati
I
Sushila
have full faith in.
as a mediator
interacted with her
and party shall appear before her when?
also. Monday or
Monday, Tuesday. my lord.
Monday, Tuesday.
That's
But,
on,
my lord,
on fifth?
Yes,
I think the petitioner for those 2-3 days, he is not in station. Maybe on Thursday or Thursday or Friday.
Eighth
Thursday or Friday. Please.
shall appear before the mediator on eighth of
September.
my lord, September 8th is Sunday.
Oh, sorry.
1 minute,
Maybe 10th, my lord.
10th.
1 minute. On tenth of
Yes.
Please.
September.
In the interim, if I may be able to take him for a couple of days, I will undertake that, 1 or 2 days, I will
That
drop
we
him
will
back.
talk, my
We
lord.
will
We have
talk.
been open to give whatever.
Let-
As a council, I'm just making submission. I will discuss
Fair
with
enough.
council and we'll
Better
work
do that even for the child also,
No, agree.
because he has
Lord,
been.
we are-
No, no, he plays
No, no,
music, his entire
He has
equipment is
been
in the house,
staying
his
with the
cycling.
father from the last
cycling
one
equipment is
year
here.
and odd.
Lord, we are very
Let him,
cognizant of it.
let him
We are
have
very
the,
We will take it. I will coordinate.
Yes,
with council.
Please, because all his, first his cycling equipment, his music equipment is here. He may want to come take it. Some arrangement will have to
We'll
be
work
done.
out. I will talk to him.
Great.
Oblige.
at what time?
6 o'clock evening.
That's better after the court hours,
Well,
Manid?
after the court hours.
my lord,
After
4
court hours,
four-
That would be
about
better.
5 o'clock or
Once we
5:30.
have to allot, there's some procedure, my lord.
Hmm.
4 o'clock we can meet physically.
Yeah,
and-
not in the mediation center, so we
No,
can.
no,
No, no.
you have to do the process and then the
By
Susila
6
madam will
o'clock.
take it off.
4:30,
We can
by
do it-
5 o'clock on.
5
by
o'clock.
5 o'clock.
But in the mediation center, we got to get it registered, the fellow file.
Yes.
Correct. Basavaraj Bannor.
Is by the wife, my lords, for a divorce against the respondent number 1 husband. The main ground for seeking divorce is that during the subsisting of the first marriage, he married second respondent herein. I have produced the photographs of the marriage. And first marriage,
What is the impugned order?
please, impugned order is that, my lord, is page number 48. My lords,
Page
just
number?
48 annexure F. Just
Hmm.
before that, your lordship. Now, this is the order where in the trial court, after issuing the notice on the divorce petition, husband, first respondent and his second wife appeared before the court, engaged the counsel. Matter was referred to mediation. Mediation was failed. My lord, thereafter he appeared 1 or twice and they requested the court for filing objections. Court has granted them a time up to more than 1 year, 2 months for filing objections. Ultimately, even after last chance, they did not file objection. Court passed an order stating that objection is taken as nil. Thereafter, proceedings went on. Evidence of the petitioner recorded. There also, he did not appear. And the matter was also, my lord, posted for arguments. There also, he did not appear. Ultimately, court, after, my lord, conclusion of the entire trial, my lord, on 19/2/24, posted the matter for judgment. On 26/2/2024, on 26/2/2024, note the respondents 1 and 2 appear before the court, filed 2 applications. One is for permission to file written statement. Another one is to recall the witness. Note these applications was contested by the petitioner, mainly on the ground that it is well settled law that once the matter is posted for judgment, sufficient opportunity granted to them, and they did not avail the opportunity.
In a matter of, in these matrimonial matters.
Please.
What will you do with that order? What will you do with the order that, by obtaining an order?
Ultimately, court will
It
have.
is a contested matter, it would, then the court will dispose it of now, will say that without granting further adjournments, that the matter be decided. Now, what will happen? No, an order will be passed against that.
No.
No, no.
It-
No,
Please,
then the judgment will be passed.
Please.
They'll come before this court.
please,
Now it will be here for another 5 years.
please,
After that, now it will be set aside and remanded.
please.
Unnecessarily, why
No, no.
the delay?
That situation, irrespective of whether it is contested or non-contested, that will continue to be up to Supreme.
It will be, no, you will
Not
be.
irrespective of whether he is contested or
have-
uncontested.
No, you will have another 5 years addition to this.
Yes, my lord, that position never changes. even if this application, petition is allowed also, because it is not ex parte order.
It will
He
not change,
appeared-
it will add, for what is a regular litigation, another 5 years will add, because once they question it,
Please.
like, before this court,
Please.
5 years, 6 years, it will be pending. At the time of final hearing, the order will be set aside and matter will be remanded to the trial court. Then again,
My submission is
your
ba-
timeline starts
Lord,
from
my
there.
submission is based on the settled portion of law laid down by the division bench of the Honorable Court as well as the Supreme Court, that once the matter is posted for my lord judgment, no applications has to, application.
Court has now the 2000 costs, some costs are imposed.
Lord, the opportunity which is granted was not availed and no reasons filed, Lord, in the affidavit for not contest.
For you,
Pardon?
what is MC filed by you?
Divorce me.
Hmm.
Please.
He is already married.
He is already married. Second marriage, and I have produced the photographs. He disowned the petitioner and first marriage, and my lord, he has begetted the children out of the second marriage, and both of them now jointly contesting the matter, stating
What is his stand?
that the second.
Never married you.
No. Yes, no. He says that they were in live-in relationship. In spite of producing the registered marriage certificate, they say it is fabricated. That is fabricated.
What is the reason stated for not contesting the matter?
No reasons assigned at all. I have produced the
Where is
affidavit.
the petition?
Affidavit.
There.
Affidavit accompanying the application. Not at page number. Not at-
That's an
Page
important
number
issue.
35, my lords.
That's an important issue. He says that you're not his wife. That's an issue to be decided by the court.
But my lord, the law which has been laid down that once a matter is posted for judgment, I am entitled for the benefit
There are
of the
so
law
many,
declared.
there are so many other judgments also. Several times when the matter is posted for judgment also, the courts have passed orders.
No, my lord, absolutely. The High Court division bench of this High Court and Supreme clearly held that once the matter is posted for judgment, no applications are maintainable. Court has to proceed to pronounce it. May I, my lord, pass on the judgment? Two judgments of this Honorable Court and the Supreme Court.
What are the facts of that case?
Lord, there also, my lord, opportunity is granted, they did not avail it. So when the person who is not
Matrimonial
vigilant,
proceedings?
plus,
Matrimonial proceedings?
no, not matrimonial. In
That's
some,
the point.
in respect of
That's the
some other
point.
context,
That's the point.
some other context.
That's the point. We'll ask the court
No
without granting,
reasons, not.
without granting further
Lord,
adjournments.
my
We'll not
respectful
understand.
submission, my respectful submission is, the husband has granted more than, my lord, 1.5 years time.
MC is 2022.
Lord, kindly appreciate the.
There
conduct.
are MC petitions that are pending from the last 10 years, 7 years, 8
No,
years.
that is not the, my lord. I am not, my lord, on the point. My point is, a person who is not vigilant in conducting the proceedings and he mutely, my lord,
Even if you have come before the court also, order would have been the same. No, there should be let's not go on these technicalities. And that too in a particular facts of the case where he denies that you are the wife. When there is no marriage, where is the question of divorce?
my lord, I have produced, my lord, but
That's your case. Yes.
I have produced the marriage certificate.
No, we'll say that we'll not let the court without granting much adjournment shall proceed with the matter. I shall pass an order.
Lord, may I make comment? Lord, in the month of February, my lord, court has to pronounce the judgment on 26/2/2024. Lord, their intention is to drag on this matter for the mainly reason that
That's why we'll fix a timeline,
3 months.
6 months.
No, here, what happened? From my side, evidence, everything is over.
First of all, otherwise this is a 2022 matter. Generally, this court is not passing any orders. Considering these facts of the case, court is saying 6 months. 3 months is a very short time. Court has other matters to attend. Please come. Agreed with them. Order dated.
Page 49.
18/7/2024. The petitioner wife is before this court. The wife had filed MC number 4412/2022 seeking divorce. It is her case that during the subsistence of the first marriage, the respondent husband had married, the first respondent husband had married the second respondent. After the summons was served on the respondent, when the respondent had failed to appear before the court. The court had heard the wife and posted the matter for judgment on 19/2/2024. Correct?
Please.
19/2/2024. And the matter was directed to be listed on 26/2/2024. At that point of time, the respondent 1 and 2 came up with an application, that is I number 4 and 5. To file their objections and permit them to cross-examine the wife. It is stated by them that during the pendency of the case, the second respondent's father passed away and he could not provide instructions to his counsel to prepare objections, which was opposed by the wife. It is a case, it is a specific case that when once a matter is posted for a judgment, the matter cannot be reopened, only the judgment has to be pronounced. They have also relied on several judgments before the trial court. The trial court, considering the reasons that is stated by the wife, stated by the husband, had allowed those applications on cost of rupees 2,000 and permitted them to file their objections. And the PW1 is recalled for the cross-examination. And the cost in cross-examination by 2/9/2024. The next part, land counsel appearing for the petitioner wife submits that when sufficient reasons, sufficient opportunity is given, the wife, the husband failed to avail the opportunities, and without any ground, he has come before the court seeking leave of the court to file the objections and also to recall PW1 for cross-examination. Land counsel submits that the trial court, without considering the law laid down by the division bench of this court and the Honorable Apex Court, had allowed the application on costs which the respondents are not entitled to file their objections at this stage when the matter is posted for the arguments. This court, having heard the learned counsel for the petitioner, had perused the material placed before the court. The parties are, the case of the respondent is that he has not married the petitioner. They were in a live-in relationship and he had married the respondent. The reason that is stated is his father expired. As such, he could not give instructions. There is no dispute about the legal portion as enunciated by this court and the Honorable Apex Court. When it comes to the facts and circumstances of this case, where the wife seeks divorce, saying that there is a marriage between the petitioner and the respondent, and the respondent comes up with an objection that he is not that the petitioner is not his wife. And these are all in the light of these respective stands taken by the parties, unless and until there is an adjudication on the merits of it, it is not in the interest of either of the parties. The judgment that he is relying on or not arising out of the matrimonial proceedings. And it would be the endeavor of the court to put an end to the litigation. In that view of the matter, this court finds no reason to interfere with the order. The husband, the MC is filed in the year 2022 and it is posted for judgment on 19/2/2024. Now the matter is directed to be listed for the cross-examination on
2/9/2024. Monday,
2024. Huh?
Monday, 2/9/24 is the next date.
2/9/2024. In that view of the matter, this court deems it appropriate to dispose of this writ petition, directing the trial court to dispose of the main MC itself within as expeditiously as possible, but not later than 6 months from the date of receipt of the copy of the order. The trial court shall not grant any adjournments, unnecessary adjournments. Next para, this court is not proposing to issue notice to the respondent as no adverse orders are passed by the court, and disposal of the case is in the interest of both the parties.
Sale number 9, Ashwata Party.
Yes,
WP is disposed of.
disposed of.
Please.
Yes. Yes,
With permission of the court, my lord. But impugned order is at 42. This is a petition on order on IA under section 125(2), enhancing the compensation awarded in a IA on an IA. Lord, kindly go to
what
page
was
number
the
50,
earlier,
sir.
what was the earlier?
Petitioner
maintenance?
1 and 2, please, ma'am.
What was the maintenance that was granted earlier?
Maintenance, no, this is the first time it is granted. Earlier in a diverse petition, it was granted. But they have challenged this before this court in an MFA, it is stayed.
Hmm.
Then application under section 125(2) was filed before a
Yes.
trial court. In that we had sought for 60,000. They awarded 20,000. For enhancement, I have come before this court. That impugned order is at 42.
Notice. Notice to the respondent.
But there is an arrears, my lord, then kindly direction may be given to pay that arrears.
Direction cannot be granted in this case. It's only we have to see the
Because
the
1.5 year is over.
party comes before the court that an order can be passed. There can't be an interim order in your enhancement petition to
No,
execute the.
what I am saying is, whatever it was ordered by the trial court, I came before this court for enhancement, but whatever it is already awarded, let that be paid.
That is what you are saying, the court to execute the order of the court by passing another order. Why should we pass another order? If the party comes before the court, then we will tell the party why is he not paying and we'll ask them to do it, not an ex parte
That is
order.
also correct, but
party-
I thought that, my lord,
Notice to the hand summons to the council appearing for the respondent and file a memo to that effect.
my lord, I'll take the summons to the counsel who appeared in MFA, here only, in this high court.
To the council appearing in the MFA.
MFA filed by the respondent,
File
by the respondent here.
a memo to that effect by 12th of September. If the memo is filed, pose this matter on 18th of September.
18th of September. 18 of September.
18. Sale number 10, parted matters, Chittappa.
We are done
Petitioner,
for the
DP Prasanna.
petitioner.
No, we'll do one thing, all these parted matters, once we'll complete this submissions and then we'll take up.
Yes.
Yes, but when,
This matter, the lordship on the last occasion, since the matter was not reached.
no, we
Lordship-
will hear it right now.
Yes.
Submission matters, that's till 22,
Very well.
we will take till 24 and do,
Very
and
well,
we'll
ma'am.
again take all the matter. Yes, 12,
For admission, sale number 12, Badrinatha. KP Bhuvan for respondent.
yes. Yes. Where is the petitioner?
Ellen.
Is there any interim order in this?
Yes.
No representation for the appellant? Pose this matter for dismissal on 3rd of September. Yes, 13,
Sale number 13.
5th of September. Yes, 13, interim order.
For petitioner, my lord.
How can it be vacated?
My lord, kindly pass away.
How's that?
In which matter you appear?
I appear for the appellant, serial number 12.
12.
In which you are, huh? Yes. Yes, what is this matter about?
Suit is filed for specific performance.
Yes.
Suit has been ex parte decree.
Hmm.
I had filed a miscellaneous
This is
application.
suit filed.
Huh?
Suit filed in which year?
2017.
2017. When was the ex parte order?
Ex parte order is on 3/12/18.
3/12? Oh. When was this IA filed?
I had filed the miscellaneous petition in the year
2021.
Date.
20.
Please look at,
Lapse of 26 months. After lapse of 26.
let's see what is the order. passed by
One more issue. Entered into a sale agreement on 23/8/2008 for a total sale consideration of 25 lakhs.
Agreement of sale is dated
23/8/2008. Sorry.
23/8.
8/11/2013.
1 minute. Agreement of sale is 23/8.
27/5/2015.
27/5.
25/7/2015.
2015.
15. Total sale consideration is 25 lakhs.
Hmm.
Advance is 7,50,000 I had received.
You have paid 7 lakhs.
7,50,000 I had been received.
You have received.
Yes.
Hmm.
Remaining 17.5 lakh is due.
Hmm.
Where after expiry obtaining the expiry decree, he had filed an execution petition. In execution petition, he had deposited the 17.5 lakh before the executing court.
Hmm.
Now I am ready to pay 20 lakhs to him.
Hmm.
If he is agreeable for.
My lord, as per bank interest, totally it becomes 50 lakh. So total, because my lord, months.
So whatever the amount deposited before the executing.
2015, I paid 7.5 lakh, 109 months. If it is calculated 1%, it will come 8 lakh 17,000. My lord, regarding 17 lakh 50,000 I deposited, it will 2019, 68 months, it will come 11 lakh 90,000. Total interest 20 lakh. So as in 20 lakh plus 25,000, 45,000 and litigation expenses,
So how much it is round figure?
50 lakh. I need 50 lakh.
No, you said 25 lakh. Where from this another 25 lakhs has come?
I not 25, I deposited already. I paid to 7.5 lakh. I want the interest. Total.
He is asking interest of deposit before the court as well as paid interest to me. If whatever the amount is deposited before the court, I have no objection, let him take the amount with interest.
No, interest will not.
Whatever I received the amount,
No, it is not on merits of it. Whatever you want, both of you can negotiate on that. The court can pass order only on the merits of it.
if this agreeable, I can proceed with the matter.
No, that you have to tell him, not to the court.
My lord, in the trial court only, they offered 40 lakh.
No, that is not
40
true.
lakh. Now they are telling before this court.
Yes, please come to the order.
Yes. Annexure B is the ex parte order which the OS suit is has been filed. May I kindly look into reasoning? Page number 37.
Page number?
Page number 37 of the trial court. In OS. Para 16, shall I read?
Why it should not be set aside? Why it shouldn't be set aside?
Because my part of contract has been completed, I deposited. Yes, purposefully intentionally.
No.
Taken.
First of all, on the ground of issuance of summons.
Yes.
Court has started presuming something. Court has presumed that according to the process server also, he is not residing in the said village. Court says his relatives are there,
Yes.
he might have informed. What are those presumptions?
Why not? It's a native place, it's a permanent place.
Will on cause will allow this petition.
Sufficient cause, he has to explain that. 26 months, he received in the execution petition, when he has filed the execution petition, he has received the notice in the same address.
Execution petition when is when?
Execution.
If you come to the order, please come to the order at page number. These grounds are sufficient. Para number 15. From the bottom about 5 lines, in this case. The order sheet invoice number 72 of 2017
Yes, sir.
shows that, please read.
It states the order sheet of OS number 20 of 17 shows that the respondent has taken a summons to court, asking and also to officer. The case for provision of the sheriff made on the summons shows that villagers have informed the process server that the defendant one, that is the petitioner hearing was not residing in the said address at present. But very admission made by the petitioner in the process examination that his family members are still residing, his family members. My lord, this is the registered agreement of sale. He received the 7.5 lakh in the year 2015. It's a native place. He has to give the sufficient reason, my lord. So, but very admission made by the petitioner in the cross-examination that the family members are still residing in the so-and-so village, so that he has got a link with his relative at village. Petitioner has a deposed in the cross-examination. Para 16, my lord. Even as per the deposition of PW1, he had relinquished the same property to the same transaction. The such circumstances, he having been released is the right in respect of his property in favor of his uncle's. The said uncle's son must very thankful to the petitioner, and he ought to have informed him about the notice and summons. Therefore, there is a very chance of being informed about the notice issued by the respondent, as well as the summons issued by this court.
Mr. Counsel, the court is inclined to allow the appeal. If you want to compromise, or else we'll pass an order allowing this application. Yes. It is submitted that there is a scope for compromise. Pose this matter next week on 5th of September. Yes, next.
Till number 13. P. Sheshgiri Rao for appellant, MB Chandrachud for respondent.
For petitioner, my lord. My lord, kindly pass over the matters.
Pass over. Next 14.
Till number
Appear for the respondent. I think they are seeking stay. There is an interim order in their favor. At the request of
Earlier, madam, sorry, interim order has to be extended.
interim order, wherever, whether they mention or not, interim order is there extent. When do you want? At the request of learned counsel for the respondent for this matter on 19th of September. Yes, next.
till number 14.
We have the appellant in this case, my lords.
Yes.
The challenge, my lords, the challenge is, my lords, to the order returning the plaint, my lords, under Order 7, Rule 10. The employment agreement, my lords, between the plaintiff and the defendant. The plaintiff, my lords, was the, yes, the suit, my lords, was for wrongful termination and damages. She, my lords, is a senior management professional in a company called Cushman and Wakefield. My lord, she was deployed in Bangalore. The offer letter also prescribes, my lords, that she will be associate vice president in Bangalore itself. The only reason, my lords, that they have prescribed that New Delhi will be the, my lords, jurisdiction is because the registered office is based out of New Delhi. My lords, the matter as it stood previously, my lords, if my lords may see section 20, if the principal place of business is said to be a different.
No, before going to the legal provisions, let's see what is it.
Yes.
So
If my lords may see the.
What is the suit for? Please come to the plaint, let the court understand.
My lords, the plaint can be referred to at page 67.
Yes.
Yes, my lords may see the array of parties, the plaintiff and the defendant. My lords may see the prayers. My lords may see page 84. May I just read, my lords, page 84.
Let us see the cause of action.
Yes, my lords, the cause of action at page 83, paragraph number 37. The cause of action to file the instant suit has arisen in Bengaluru, that is within the local limits of the jurisdiction of this honorable court. The plaintiff resides in Bengaluru and the office of the defendant, in which the plaintiff has worked from the beginning, is in Bengaluru. The appointment letter was also signed by Mr. Rajesh Nair, Director, Human Resources, and by the plaintiff at Bengaluru. 38. The instant cause of action first arose when the plaintiff was initially forced to submit her resignation from the defendant company on 27/4/2020. The cause of action further arose on all dates mentioned herein above when the plaintiff exchanged emails with the representative of the company, that is Ms. Deepali. The cause of action further arose on 8/6/2020 when the hearing of the independent committee took place on 24/6/2020 when the said IIC report was pronounced. My lords, the sum and substance, my lords, if I may summarize, is this. She was appointed as the Associate Vice President in Bangalore. She had absolutely no role to play in any other city but Bangalore. She was, my lords, wrongfully terminated by certain actions pursuant to an internal committee, my lords, which was constituted, which is also at Bangalore. Now, the defendant, my lords, appears and files an application under Order 7, Rule 10. My lords may kindly peruse the application at page 87.
Yes.
My lords, the prayers at page 87, which is to, my lords, return the plaint for want of jurisdiction. The relevant, my lords, paragraphs are at page, my lords may kindly see page 89. I'll start with page 88, my lords, and then move to page 89. Page 88, para 3, my lords. That the defendant, my lords, has got that, my lords. That the defendant has its registered office and carries on business at New Delhi, which is the registered office in India. The plaintiff was issued an appointment letter dated 10/4/2019 from New Delhi after an interview and was posted to Bengaluru branch. The plaintiff was discharging her duties to all branches in India with operational control being exercised from the registered office at New Delhi. The issues that have now been raised and reliefs claimed by the plaintiff have arisen out of this appointment letter. The bundle of facts that surround this suit and the cause of action clearly show that the cause of action stems from the appointment letter dated 10/4/2009.
As per your appointment letter.
Yes.
Clause number 9 says that the courts at New Delhi has jurisdiction with regard to any of the dispute between the parties.
Right.
Now please come to the order of the court.
Yes. Before that, my lords, may I just trouble my lords with the objections to show what I have pleaded as to the cause of action. My lords may just kindly see the objections before that.
Whatever is the cause of action, there is an agreement to contract between you and the employer.
That's right.
And you are bound by the terms and conditions of the employment.
Yes.
As per that, only the courts at New Delhi have jurisdiction.
That's right.
So now how do you, because you're working in Bangalore,
Yes.
will the courts at Bangalore will have jurisdiction?
That's right. That's what I want to.
In terms of your agreement.
My lords, in fact, let me just point this out, my lords. The explanation to section 20 now, which has been introduced, changes, my lords, that the jurisdiction no longer rests with the registered office. If, my lords,
No, it's not about the registered office.
Yes.
It is about the clause in an agreement which both of
Yes.
you.
It
have
captures that.
conferred the jurisdiction or say that only the courts at Delhi have jurisdiction. That's the issue.
That's right.
Yes.
So, my lords, my submission is twofold. Number one, my lords, the explanation 20 now pushes jurisdiction from the registered office to the subordinate office. In addition to that, my lords, all the bundle of facts which have arisen, my lords, are from
Clause
Bangalore.
9. Now, the whole basis of filing the suit is your
Yes.
agreement between you and your employer.
That's right.
What is the agreement? You have entered into an agreement saying
There's no
that
dispute on that.
any litigation should be at Delhi.
That's right.
Then now the court said, no, it is not about whether you're working in an office at Bangalore and the main office at New Delhi. Those are not the considerations.
My lords, according to me, my lords, with the law as it stands today, there is a revision in the consideration which has to be, my lords, looked at by this honorable court. If merely the jurisdiction is New Delhi because the registered office is there,
Not
explanation.
registered office, you have agreed for it.
Yes.
It's not on
that
that
is-
ground.
My lords, it's like this. As per section 28 of the Indian Contract Act, both parties can agree on a jurisdiction. If there are two, my lord, cities which have jurisdiction, you can limit it to one city, provided the other city also has jurisdiction. So if both cities have jurisdiction, you can limit it to one. But it is my case that New Delhi does not have jurisdiction merely because it is a registered office. And that is what, my lord, section 20 is now prescribing in the explanation. And my lord, the Honorable Supreme Court on a very, very similar circumstance has also held, my lords, in Patel Roadways, that merely because the employment agreement prescribes that the registered office, that is New
Pass
Delhi.
on the judgment.
Yes, please. You have the additional. That, my lords, was not even considered by the learned trial court.
Why then what is the purpose of specifically mentioning the jurisdiction of the court?
My lord, that's the difficulty, my lord. Most employers today, even though I'm employed in Bangalore, my lords, pushes jurisdiction to a completely different city because it then deters me from, my lords, filing a litigation. That, my lords, if my lords may see, Patel Roadways has been read down. I'm just going to, my lords, pass on that judgment. Patel Roadways.
Take that. Yes.
Yes, my lords may see the facts at page 271, internal page. My lords, is a 3-judge bench of the Honorable Supreme Court. May I just read, my lords? Page 271, the first paragraph.
Page 271.
Yes, the internal page 271.
Yes.
The appellant carries on business of a carrier and transports goods on hire. It has its principal office at Bombay and branch offices at various other places. The respondents entrusted consignment of goods to the appellant at its subordinate office in Tamil Nadu for delivery to Delhi. The goods had been transported to Delhi by the appellant, but in damaged condition. The respondent instituted suits for damages in the courts at Madras. My lords may kindly note that. Within whose territorial jurisdiction the subordinate office was situated. The appellant inter alia took the plea in its defense that in the contract entered into between the parties, they had agreed that the jurisdiction to decide any dispute between them would be only within the courts of Bombay. And consequently, the courts in Madras, where the 2 suits had been instituted, had no jurisdiction. Well, it's identical to the facts of our case. If my lords may see the treatment by the Honorable Supreme Court, my lords may see page 274.
Yes.
Yes. My lords may see page 274, paragraph number 6.
Yes.
Having heard learned counsel for the parties, we find it difficult to agree with this submission. For the sake of convenience, section 20 of the code, except the illustrations, is reproduced hereunder. Other suits to be instituted by defendants reside or cause of action arises. Subject to the limitations aforesaid, every suit shall be instituted in a court within the local limits of whose jurisdiction A, the defendant or each of the defendants, where there are more than one at the time of commencement of the suit, actually and voluntarily resides, or carries on business or personally works for gain, or B, any of the defendants where there are more than one at the time of commencement of the suit, actually and voluntarily resides, or carries on business or personally works for gain, provided that in such cases either the leave of the court is given, or the defendants who do not reside or carry on business or personally work for gain, as aforesaid, acquiesce in such institution, or C, the cause of action wholly or in part arises. Explanation. My lords, this is important. A corporation shall be deemed to carry on business at its sole or principal office in India, or in respect of any cause of action arising at any place where it also has a subordinate office at such place. May I just read that once again, my lords, and then I'll provide my argument on this point. A corporation shall be deemed to carry on business at its sole or principal office in India, or in respect of any cause of action arising at any place where it has also a subordinate office at such place. My lords, the law as it stood back then was that the moment you have a registered office in one particular city, automatically cause of action is deemed to be from that particular, my lords, city, because the registered office is located there. This explanation makes a further, my lords, concession. If you have a company which has multiple subordinate offices, and let's assume all the cause of action has arisen in the subordinate offices, then the cause of action is deemed to have arisen only in that subordinate office. May I just read that again, my lords? A corporation shall be deemed to carry on business at its sole or principal place office in India, or in respect of any cause of action arising at any place where it also has a subordinate office at such place. In this case, my lords, Cushman Wakefield has its registered office in New Delhi. According to me, I have not gone to that office a single day. My termination, my appointment, everything happens in Bangalore. My immediate management, my lords, whose supervisors appointed for me are also based out of Bangalore. But I am dragged to, my lords, New Delhi because I am now claiming, my lords, that the termination was wrongful. Now, please see what the Honorable Supreme Court holds. After, my lords, analyzing the explanation, my lords may see page 276.
Yes.
My lord, may kindly see page 276, my lords.
Yes.
The paragraph C, D, and E, my lords. In that event, may I read just from the line before that? The first part of the explanation applies only to such a corporation which has its sole or principal office at a particular place. In that event, the courts within whose jurisdiction the sole or principal office of the defendant is situated will also have jurisdiction, inasmuch as even if the defendant may not be actually carrying on business at that place, it will be deemed to be carrying on business at that place because of the fiction created by the explanation. The latter part of the explanation takes care of a case where the defendant does not have a sole office, but has a principal office at one place and also has a subordinate office at another place. The words "at such place" in quotes are occurring at the end of the explanation.
Urgent notice to the respondents. 23rd of September.
Grateful.
Yes, next.
May I also serve, my lords, the counsel appearing below.
It is returned now, the council might not be there.
Please.
Cell number 15, Raghunath MD.
I appear for the appellants, my lord. There's a short point, my lords, with respect to appellants.
What has happened to this notice to the respondent?
For paper publication, my lords, has been taken.
When is it filed?
But also, if I may make a humble submission, this is a petition filed for the sake of selling the trust property, my lords, seeking permission from the Honorable Trial Court to sell the trust property. In fact, before this,
What has happened to the notice to respondent? That
the paper publication has been taken, my lords.
Then
There are
was it
there are no respondents also as well. It is, the respondents are nil, my lords, basically.
So where is that? Where is that, whether it's recorded that the notice to them is
On the 16th July 2024, my lords, that has been filed, showcasing that
as the order that he has taken on notice in Kannada and English and he had filed a memo on copy of the memo taken on post. Whom you have shown as respondents in this?
it is nil, my lords. There are no respondents.
Please come to para 12 and read.
Please, my lords. If I may be permitted, my lords. It says, more importantly, the recitals of the trust deed go to show that the founder had created the trust for the benefit of certain persons named in the Schedule B of the trust deed and to enjoy the income that would be derived from the scheduled property apart from using the said premises for their residential purpose. The terms of the trust deed do not provide any option for the beneficiaries to sell the property or to use its sale proceeds for their benefit. On the other hand, clause 9 of the trust deed goes to show that the founder intended continuation of the trust till the death of the last survivor amongst the beneficiaries, and then only the trust should extend.
Yes. The finding of the court is there is no,
Please.
the trustee do not permit any of you to sell the property. And in case there are no lineal descendants, that should go to a temple.
I agree, my lords. My only humble submission is this. In the trust deed, if I may bring to my lord's attention to the trust deed itself. At the trust deed, my lords, it was initially executed for the sake of the beneficiaries itself, my lords. The right title as well as the interest of the trust property was already granted by way of the trustee to the beneficiaries, my lords. My
What do
only,
you say about clause number 9?
I understand, my lords. My only humble submission is this. The trust was executed for the existence of the trust property. What happens, my lord, when the trust property itself ceases to exist? It does not even exist. Because I have produced the photographs at Exhibit P11, if my lords may kindly peruse the photographs. The trust property has been in a dilapidated condition and the buildings has actually been broken down and fallen down, my lords. When that is the scenario, if I may bring to my lord's attention to section 77 of the Indian Trust Act, which clearly states, my lord, that when a trust or how a trust is extinguished is when its purpose is being fully fulfilled, completely fulfilled. B, when its
What will
purpose
you do?
becomes
To sell the property, and what will you do?
My lords, anyway, there is no money coming out from the property as of now. At least it could endure to the benefit of the beneficiaries because the entire aspect for the
You
trustee,
utilize the same for some other purpose.
the problem is, my lords, there is no income coming.
You can construct it.
There is no funds even for that, my lords. That is the only problem.
You can lease it out.
My lords, may kindly peruse the photographs. The trust property itself, there's no building existing as such, which means the payments which the petitioners would do is from their pockets, but all the payments have already been made by way of the taxes and other things, my lord. Now they do not have any other money left to even renovate or build a new building over the trust property. Hence,
Without construction, what else you can do?
there's nothing, my lords. It could not.
What is the nature of the property?
It's the nature is it's a residential land, my lords. When it's a residential land, and there has to be some kind of a building for a person to reside in it, my lords. Because if my lords may kindly peruse the trust deed as well, the intention of the testator was that the beneficiaries should reside in the property, if not, rent it out itself to the said individuals, whoever would be willing to reside in the property, my lords. When there exists no such building,
The extent of the land.
extent of the land, my lord.
There are so many beneficiaries.
Please, my lords. 25 by 82, my lords, is the trust property size.
Yes. No, all of them are before the court.
Yes, my lords, all of them are before the
How
court.
many are there?
There are, my lords, 6.
There are only 5.
5, my lords. The other one predeceased, my lords. At the age of 7, one of the sons of the erstwhile trustee deceased, my lords. Predeceased the entire aspect itself. Hence, the only remaining surviving trustees and beneficiaries are before this honorable court. And also, if I may make a humble submission, my lords, under the Schedule B of the trust deed, the names have already been mentioned, my lords. The present petitioners' names have already been mentioned under the Schedule B of the trust deed. Hence, my only humble submission is this. There is no income being.
But contrary to the wishes of the person who has created the trust, how can you do it?
I understand, my lords. My only humble submission is.
To sell the property, there is no trust.
My lords, first of all, there exists no trust now because of the non-existence of the building itself. If I may bring to my lord's attention to section 77, subsection
No, if the
C, my
building
lords.
is not there, but the property is a valuable property.
My lords, the building, the property was given along with the building, my lords. That was the trust testator's will. In fact, under the trust deed, the initial owner had clearly mentioned.
By selling the property.
My lords, of course,
It's gone.
the entire.
No, one of the clause says that
Please,
after
my lords.
these descendants, it should go to, if nobody is there, then it should go. Then
No,
how will that be fulfilled?
I understand, my lords. If I may bring to my lord's attention to the trust itself, if my lords could kindly peruse the trust deed at the first paragraph, if I may bring to my lord's attention.
Why always two councils are arguing? Yes.
If I may bring to my lord's attention, my lords, in the first aspect of it, if my lords may kindly peruse para number 1, wherein for the purpose of effectuating the intention and the desire of the trust and the settler does hereby settle, grant, convey, assign, and transfer onto the trustees above named the trust premises and trust for the purposes and with the subject to the powers and provisions hereinafter expressed and concerning the said, and the deal with the same in the manner provided below, my lords. The provision below is that if there exists a building and if the same building has been rented out, then the said premises could continue as that of the trust. But what happens, my lord, that there exists no such building? That is when clause 9 comes into the picture, my lords. I agree. Clause 9 comes into the picture where it
Clause
says,
9, thereafter clause 10.
yes, my lords, after the death of the last survivor, then it would act as that of a succession itself under the Hindu law itself, my lords.
No, the fact is you want to dispose of the property and you want to divide that whatever the proceeds that comes out of it.
My only humble submission is this, my lords. If my lords may kindly peruse, that the intention was that there should have been a building in the trust premises,
That is
and
one.
that should have been, yes, my lords,
That
that
is
should have
one.
been rented out or
It has a further intention also.
true, my lords. Assuming, my lords, that only the last survivor deceases, that is when the descendants would be.
That is
in.
the case, you should
I
come
agree.
out with something
Please, my lords.
which will keep the trust alive, and also it goes on for generations.
My only humble submission is
How
this,
do
my
you
lords.
do it?
My
Not
only,
that the solution is not that you people will sell it and take your proportionate share and you'll keep everything.
I agree, my lords. My only humble submission is this. When the intention was to give the said trust premises to the beneficiaries itself, and the prime.
Is you should enjoy the proceeds that
I
comes
agree,
out
my
of
lord.
it.
But there are
How
no
do you
proceeds
do
coming
it
in, my lords.
without selling it?
That was already been discussed among the trustees and the beneficiaries, my lord. The only problem is it is situated in such a location that it is done in a narrow lane. And in the narrow lane, nobody is willing to come before the trustees or as well as the beneficiaries to take the premises because it's already in a dilapidated conditions, my lord. Nobody is willing to put in more funds as that of the tenants, my lord, to
You
take
can
into
take
consideration.
You can take loan, build something, and whatever that comes from out of this, you can as well repay that loan.
But for that, my lords, there is no funds. It was already been discussed among the trustees and the beneficiaries, my lord. This was not taken as a abrupt decision by the trustees or the beneficiaries,
You
my lord.
have no such right to take such decision.
I agree, my lords. But when the intention was with respect to the building itself, the
Again,
trust
you're
does
coming
not
back
even
to
exist.
that. His intention is not only that, he has other intentions also.
Other
So
intentions,
you
I
have to
agree,
look
my
at
lord.
all his intentions, not which is
My
which
lords,
is
these are
acceptable
subject
and
to.
which is
These are
beneficial to you.
these are subject to, my lord. Subject. The clause number 9 and 10 are subject to other clauses which was mentioned in the trust deed. Even otherwise, my lords, I would again.
We have to read all the clauses,
I agree, my
together,
lords.
there should be a harmonious
Interpretation of it. I agree, my lords. My only humble submission is, if this honorable court deems fit to provide any kind of a condition, we are ready to do so, my lords.
We'll pass out reserved, third reserved. Yes, next.
Please, my lords.
16,
Much obliged.
Your Charan.
Kindly recollect, on the last occasion, my lord had,
I just want to.
Is the petitioner, let him say what it is, yes.
Something which Melody is not brought to the knowledge of the
my lord, lordship may kindly recollect.
Let
on
him
the-
say where it stopped, then
Yes,
you
yes.
can continue from there.
My lord, let me
Let
make
him
submission.
say,
My
that's his
appeal.
petition, yes.
Lordship, on the last occasion, my lord, I directed to the register to get the
If
Kannada
what has happened
translated
at
version
last
of clause 7, my lord.
That's before that has been looked into, maybe one submission.
Yes. Yes.
That's the complaint which is being lodged against the appellant. Has a charge sheet has been filed. Cognizance has been taken. All these events.
It was not as on the date the order
Please,
is
It was
passed.
please.
prior to that. That's precisely the point, Millards. What happened is, thanks to the recording, Millards had the benefit to go through the arguments. Millards may look at two documents of the exhibits. Exhibit number P9 and P10. P9 is the copy of the complaint. The FIR, Millards, dated 30/7/2018.
Yes.
The charge sheet is dated 14/10/2018. Now, and his affidavit is dated 14.
When did you file the petition? Petition, election petition, when was it filed?
The election petition.
2019, my lord.
2019. Millard's the affidavit on which he goes on to say that there is no criminal case pending, assuming that Millard's charge sheet and everything. The affidavit is dated 14/5/2019.
Why such a fact was not brought to the notice of the court? You are saying that no charge sheet is filed.
Please no, my lord. In fact, my lord, a PCR complaint was filed. Not before that, on,
Are you denying this charge sheet?
charge sheet was not filed, my lord.
That's the exhibit, my lords. My lords,
Please.
the exhibit we take.
You don't
We
have,
take only.
you don't have the exhibit?
No, my lord, I'll.
Give it to him.
Exhibit we can.
Look at it, we'll take after lunch.
Yes.
This next matter,
Please, no.
next matter.
Documents.
Cell number
Charge sheet agreement.
17,
Idea.
17,
Prepare for the appellants.
Yes,
Not suit is for injunction, notes, and the appellants are before this court, notes, challenging the order, notes, dismissing the application under order 39 rule 1 and 2 of series. The plaintiff, appellant is the plaintiff, notes, and who is the absolute owner of the suit schedule property, notes. Which she was.
so the owner of the property.
Yes, yes, notes.
What is interference of the defendant according to you?
Now, my lord, so she was intending to construct a compound wall within her premises, my lords. And the defendants, my lords, are obstructing her from constructing the compound wall, and also, my lords, are interfering with her peaceful possession of the property.
What is the case of the defendant?
They say, my lords, that the proper in which she is constructing the compound wall, my lords, is a public road, my lords. Now, my lords, we have also produced the building license, which discloses the road, my lords, which is on the western side.
According to the defendants, you are encroaching the road and making the
Please,
construction.
please, my lords. Now, my lords, the road is on the
In
western
that
side.
regard, any complaint is given by the defendant to the BBMP?
No,
or
on
whatever is the
initially, my
municipality?
lords, way back in the year 2006, they have given a complaint, my lords, and BVMP has not taken any actions because, my lords, that property.
Come to the impugned order.
Please, my lords. And another reason, my lords, for rejecting the application, my lords, that she has not produced the sale deed of her husband who originally purchased the property, my lords.
Let's see the order in here.
Relevant portion, para 9. Plaintiff supported the IN number 1 produced a gift deed dated 6/11/2006, executed by her husband, Sri P.S. Rajan, in respect of site number 16, old number 924, so and so on. The plaintiff produced Kata extract dated 8/2/2011, standing in her name. The plaintiff has also produced encumbrance certificate from 1/4/2004 to 23/5/2004 and 1/4/1990 to the 31/3/2004, which discloses that Sri P.S. Ranjan, who is husband of the plaintiff, acquired the suit schedule property under registered sale deed from Sri Kata Varayan. The defendant number 1 and 2 has denied the extent of claim made by the plaintiff over the suit schedule property, stating that the plaintiff is trying to encroach public road. There is no site as claimed by the plaintiff. The defendants number 1 and 2 have also produced complaint lodged by them to the BBMP against the construction intended to be made by the plaintiff for the suit schedule property. Defendants have also produced the judgment copy of OS 17342 of 2006. The claim of the plaintiff is based on the sale deed dated 13/2/1991 of her husband Sri Ranjan. The plaintiff has not produced the sale deed executed on 13/2/1991 by Sri so and so minutes, husband of the plaintiff, in respect of suit schedule property. Said sale deed is important to ascertain the claim of the plaintiff under registered gift deed dated so and so. In the absence of sale deed of plaintiff's husband, it is not possible to ascertain that the extent of suit schedule property and its boundaries, which is claimed by the plaintiff. Under registered gift deed, it is noted here that OS 17342 of 2006 is
When
filed.
is this complaint on receipt of the, this is a suit of 2006?
That earlier suit, my lords, which is dismissed for non-prosecution. This plaintiff has not tendered for cross-examination, and accordingly, the earlier suit was dismissed. Now, my lords,
Injunction in a 2006 suit, when is this
no,
order?
no, the present suit is of the year 2023. This suit is earlier suit, which is dismissed for non-prosecution, wherein plaintiff was obtained the interim order as against other different defendants, not these defendants. They have only in respect of.
No injunction from 2000.
No, my lords. In 2006 suit.
It was there.
Yes.
When was it dismissed for default?
In the year 2022, my lords.
Thereafter, again, my lords, these different defendants, my lords, have interfering with her peaceful possession. My lords. She has constructed the house. Initially, the suit in the year 2006.
So somewhat the facts are not, the petition is permitted to take out
My lords, may I kindly see the khata, which is also stands in the name of the
petitions are- so
plaintiff.
Here it is not about your land, it is about you approaching the road and making the construction.
Please, my lords,
The
my lords, I have
petitioner
furnished the photographs.
The hand summons on the respondent, we shall file a memo to that effect by 17th of September. If the same is filed, pose this matter on 23rd
Lords,
September.
may I make one submission, Lords? May I kindly see the photographs, building plan as well as the boundaries mentioned in the sale deed, my lords, wherein there is no road on the western side, my lords.
We'll see, we will dispose it off on the day.
Please.
Get it on
My lord,
23rd.
till then, my lords, they shall not interfere with her peaceful possession. She is residing in that house, my lords.
What is the interference? They are not saying anything. They are only saying about the road. They are not saying about your building.
Please,
So there cannot be any injunction. Yes.
Till
Yes,
number
ma'am.
18
Obliged.
adjourned, 19. P.N. Shetty. Abhinav Ramanan.
Which is, you called item
This is 20.
19.
19.
P. Sheshgiri Rao. Passover.
Yes, Passover, next 20.
20.
My lord, I am appearing for the petition, my lord. Husband's petition, my lord, regarding maintenance. The trial court has granted 40,000 rupees maintenance, my lord. That there were challenges in writ petition, in appeal, in admission, my lord. This court has granted an order, passed an order saying that, my lord, 10,000 to the first petitioner and 5,000 to the remaining two daughter and son. My lord, that petition was, after the order, they appeared and filed an application for vacating the order, saying that that amount is insufficient. After hearing both sides, my lord, court held that, my lord, it is sufficient because she is already working in a government department. The wife is also working, husband is also working. Court said it is sufficient and court rejected his application. Now he filed an application with calculation, my lord, the amount is not paid properly, complete. What is the order passed by this court?
It is what is it now filed?
He filed a calculation saying that the amount,
Saying that already the RPFC is disposed of.
no, RPF is not disposed. The
Yes, I- you're
application for
saying about
vacating is rejected his application for vacating
Let
the.
him come if that's the case. we will hear.
But only thing is, my lord, I am under medical treatment. I could not able to stay because I am taking home.
When do you want?
You lost me a bit of one after. I'm having the order of the court also, saying that entire amount is paid and it is
No,
cleared.
There is no representation on behalf of the respondent. Then counsel for the petitioner seeks time, medical grounds. Pose this matter on 18.
Maybe chemotherapy, chemotherapy I'm taking, that's why I'm requesting your lordship.
When
Any convenient after the 1 month.
pose this matter on October 14.
But trial court has given a finding that I have completed every amount is
October
paid.
14. Yes.
Till number 21 disposed. 22. Srinivas V.
My lord,
Public
kindly
hearing.
pass over. Pass over.
Yes, next.
Preliminary hearing B group 23.
Can be of the petition, please.
Yes.
Well, this is arising out of an interim order that is being granted. Though in favor of the petitioners, but my lords, this is with respect to a child. My lords, they also previously passed an order.
Counsel for the respondent.
My lords, counsel for respondent, the last date has filed a memo for retirement. There was, despite several directions that were given, and also the matter passed over on that particular day for the respondent to appear. Respondent has not appeared.
Yes, Mr. Shauri.
My lords, yes, on the last date, my lords, I have informed, but my instructions in these matters, my lords, personally, I think she is complying with that order, and there is a talk of settlement, and they are ready, they have already worked out on the issue of dissolution of their marriage, my lord. So only need to be formalities need to be executed.
Here.
I don't know.
In fact,
Last
there
time
is
there
no
was other
divorce proceedings
counsel.
pending.
Now,
There is only an RCR petition that has been filed by the petitioner here.
my
And also,
only
there is a memo of retirement that has been filed by
yes,
the
my lords,
respondent on the
I
last
know
occasion.
that. I don't have
I have
anything
not
to
seen the
say,
child for
but
the last 3 months. My lords, I have
since
given them
nobody
an
has
opportunity to
represented,
see the child
I'm
due
just
to
bringing
summer
the
vacation.
claim to them.
I have not seen the child post.
The mother shall be present before this court along with the child on 2nd any matter is there on 2nd September?
In chambers, ma?
Yes,
Yes, yes.
2nd September. 2nd September at 5 PM. Both the parties along with the child. Yes.
Cell
24.
number 24. Hindu you.
I appear for the petition.
Where is
my
it?
lords.
What has happened?
Last time,
PB Raju?
visitation, he informed that he's not coming forward.
He's
So-
not coming.
No, he didn't come. He didn't come, my lords.
Did you see?
Papi is present before. Respondent is present before the
Passover?
court. Yes, my lords.
Come back to that departed matters.
Parted matters, serial number 10. Serial number 10.
Yes.
For the petitioner in this matter, my lord,
Where is the counsel for the respondent?
the morning, here, he was here in the morning when the,
Oh.
it was there. I
We'll
saw
take
it
up, we'll take up after lunch,
after-
along with the passwords. Yes, next.
Serial number
11.
11.
Yes.
Sarvana S.
Neither of us have moved the matter, my lord.
Huh?
Neither of us have moved the matter. Seems like a report is furnished by Nimhans that is placed before your lordship.
Yes, give the report. You said neither of us moved the why the mother was every day taking the child out of the hospital? What for she is admitted in the hospital? Every day at 6:30 AM she takes, get the child back at 4:30. What is she expecting the hospital authorities to do? School also gave the permission, court said it cannot be. Why was she taking? Doctor never suggested. They said that it is the mother who is repeatedly asking them for a dance class, for that class, this class. It appears that mother do not want her to be evaluated. Once she is evaluated, things will come to light, which she is not interested. It is in clear violation of the orders of the court. The child so-and-so admitted and enhanced at the behest of the court order dated 26/7/24 has been inadequately observed by the treating team in view of the development of subsequent physical illness and subsequent treatment in multiple hospitals. Further hospitalization for observation and relevant psychometric assessment is warranted to help the treating team to come to counsel the child. It has also been observed in the brief 2-3 days hospitalization that the process of child leaving at 6:30 a.m. from the ward, coming back from back around 5 p.m. in the evening, with further carrying out her daily routines, leaves inadequate time for the team for observation, especially as the child appears to be physically drained and unable to participate in a session. We also acknowledge the fact that the child needs to attend her school as is important for well-being. It might be deemed useful if the school authorities were to relieve the child so that she could return to the ward by 3 p.m. for adequate observation and time for the planned sessions. The family has been asked to get readmitted on 28/20/24 for reinitiation of evaluation management. What has happened then? 28/20/24 is not tomorrow. It is already done.
Lord, in fact, last Saturday, they wanted to recommence the evaluation. Lord. She sought for 1 week's time. Accordingly, 28th was granted. As
28 also you didn't turn up. What happened on 28? What has happened? Why you want, how many weeks you want? Then the court, so tell your client that the court's impression is that the mother is not in the welfare of the child. She wants the child to continue in the same state of mind where she talks about so many things. Mother's intentions are not at all clear. Tell your client. Tell your client that she wants any orders from the court wherein completely the child will be admitted under the custody of the father so that he will take care of her health. Mother is only interested in the dance class. Mother is interested in other classes. Just for 4 weeks, when the school itself has said that it can be, you take the girl at 6:30 a.m., gets her back at 5 o'clock, and you tell the court that she is trained. Won't she be? You are only interested on the academic, not on her complete growth. But it is not about saying your act should demonstrate that you're doing something. How much time the court has to give you? How many times this matter has underwent adjournments? Tell her, you please, basing on this report, you please file an affidavit before the court that what is it going to be? Basing on that, I'll pass orders. Because it's been a long time and a long rope.
One other aspect,
and court will also observe that the mother's intention is not in the welfare of the minor. And don't push the court to make such an observation.
One other aspect, my lord, the doctors are requesting that they cannot withhold the special room for long. They're requesting to recommence the visitation at the evaluation at the earliest. They cooperate.
A report is placed before this court by the enhanced stating that for various reasons, they could not give the treatment to the child. And it is also stated that for the purpose of school, the girl is leaving at 6:30 and coming back in the evening. Earlier, the school authorities have also given permission for a period of 4 weeks or 6 weeks.
6 weeks.
6 weeks for the child. Though this court had passed an order long back by filing one application or the other, on one reason, on one pretext or the other, so far, they could not give any treatment, nor they could come to any prima facie opinion about the state of mind of the girl. Considering the peculiar facts and circumstances of this case, finally, the mother is given an opportunity to admit the child tomorrow, tomorrow and enhance, and the mother shall adhere to whatever the directions or the advice that is given by the doctors at enhance. She cannot take her own independent decision, and she cannot take the child wherever and whenever she wants. The doctors shall treat the child, and the interest of the child should be the paramount consideration, but not what the request that the mother makes. The doctors, the enhance is directed to evaluate the child at a stretch without giving scope for any kind of request from the mother. And from tomorrow, in the next 6 weeks, at a stretch, the counseling and counseling of the therapy shall be completed, and the report shall be placed before the court. This is a final opportunity to the mother, and if she is not cooperating with the hospital authorities and coming up with any kind of excuses, the court has to consider that court has no other option but to come to the conclusion that the mother is not acting in the interest of the minor. Yes, next. Handling.
May I request, my lord, instead of this, let the registrar make a communication to the nimans. Let the registrar make communication to the nimans of the order.
The registrar judicial shall communicate the order forthwith.
Great.
That do it in priority, that order.
Great.
No adjournments now.
My lordship, in kind permission, my lord. Serial number 28, my lordship.
No adjournments now.
No, my
It
lordship.
Can be done
It
only
is
in the morning.
matter is, it is the subject matter of 48 lakhs. It is matter to the division bench, my lord.
28,
my lord.
Land counsel appearing for the petitioner submits that. Appellant submits that the valuation of the suit is how much?
47 lakhs 58,427, my lord.
47, write it on a paper.
Yes.
47 lakhs so and so. And it has to be placed for, and it has to be placed before the division bench. The registry is directed to place this matter before the division bench. Yes, next.
Much.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ಆಯ್ತು?
ನಿಮ್ದು ಯಾವ್ದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್?
29 ಅಮ್ಮ.
ಸೀರಿಯಲ್ ನಂಬರ್ 24 ವರೆಗೂ ಆಗಿದೆ. 25 ಇಂದ ಕಾಲ್ ಔಟ್ ಆಗ್ಬೇಕು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪಾಸ್ ಓವರ್ಸ್ ಇದೆ.
ಮೇಡಮ್
ಪಾಸ್ ಓವರ್ಸ್ ಇದಾವ?
28 ನಡೀತು. 20 ಸೀರಿಯಲ್ ನಂಬರ್ 28.
25 ಇದೆ ಸರ್. ಅದೇನೋ ಬರ್ದು ಹಾಕಿದ್ದಾರೆ. ಅದೇ ಅದಕ್ಕೆ ಅಪಿಯರೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಬರುತ್ತೆ. ಅಂಡ್ ಡೆಲಿವರಿ ಇಸ್ ಪರ್ಮಿಟೆಡ್ ಅಂತ ಮಾಡಿ
Some more criminal cases registered against him. It's a case of the appellant herein in the election petition that the party who come to the court shall come with clean hands. And the respondent herein, first respondent herein has not disclosed all the relevant facts. Basing on the pleadings of the parties, the court had framed the following issues, all the 4 issues, extract. On behalf of the petition, on behalf of the respondent number 1, petitioner, he got marked 14 documents are marked as exhibit P1 to P14. And he himself examined as PW1. What is that exhibit? Charge sheet. Exhibit P10 is a charge sheet where charges are leveled against the petitioner under section, against the appellant under section.
5 sections, my lord, I'll read it.
Charge sheet is dated 11/12/2018.
11/12/2018 under section
144, 143, 323, 324, 506, 504, 149 of
you have written all. Please repeat again.
143, 144, 142, 323, 324, 504, 506, 149.
IPC. The punishment for the said offences. What is the punishment?
That's it, same.
Lord, for 144, it is 2 years, 148, it is 3 years, 323, it is 1 year, 506 is 7 years.
There are, and the maximum punishment for the offences, for the charges framed against the appellant, maximum is 7 years. The trial court, the court had allowed the election petition and they declared that the election of the appellant herein, which was held on 29/5/2019 to ward number 7 of Sharif Mohalla, Kunigal Town, Tumpur, is void and the same is set aside. Consequently, the first respondent herein is declared as a duly elected candidate for ward number 7 as duly elected candidate. While passing such an order, the court had observed that during the course of cross-examination or of RW1, it is elicited from the appellant that CC number 1313 of 2018 is pending on the file of the principal civil judge, which supports the case of the respondent that there is non-disclosure of the said case in the nomination. It is argued by the appellant herein that as it is registered on the basis of a private complaint, he had no knowledge of the pendency of the case. But during the course of arguments, a memo is filed with the respondent herein has filed a memo with order sheet of the said case. Under the order sheet is issued by the concerned court. And the court observed that the court can take judicial notice of the same, since the document is a public document. And as per the said order sheet, the appellant herein on 25/4/2019 even before filing of the nomination, appeared before the court and obtained the bail. And the said fact is not disclosed in the nomination, which goes to show that the respondent intentionally had not disclosed the said fact. Even during the course of cross-examination, the said aspect was put into the witness, stating that column number 7 of page 3 of exhibit P4, you have not disclosed correct information, for which it is deposed that you do not have the knowledge of pendency of the case. Once the bail is obtained, the question of appellant having no knowledge of the said case do not arise, and it appears that only to escape from the clutches of law, he is deposing falsely. Further, it is also admitted that on 13/5/2009, he filed the nomination and he has obtained the bail on 25/4/2019. No, I am looking at.
Page number 19.
The court has also considered the fact and the submission of the appellant that there are criminal cases pending against the respondent number 1, and that he had not furnished correct information with regard to his avocation, family details, and property details. The respondent has produced documents, exhibit P4 to P4, 8 and 14, to show that the appellant herein has not disclosed correct information with regard to pendency of the case. As such, his selection as a counselor is is declared to be as void. The appellant herein, based on the complaint lodged by the petition by the respondent, exhibit P1, has not taken any action in furtherance of the complaint and issued an endorsement as per exhibit P3. As such, on this count also, the election of the appellant herein is liable to be set aside. The court felt that as there is suppression of the facts, that there is a criminal case filed, the case is registered and a charge sheet is filed against the appellant herein. The election of the election of the appellant is declared as void. Then the court has also discussed about the aspect of limitation. On that issue, it is observed that the election of the councillors came to be notified by the government on 9/5/2019. The election petition was being presented for adjudication to the court within 30 days from the date of publication of result as required under the Act. So on perusal of the material on record, there is an improper acceptance of nomination, and non-compliance of the provisions of the KMC Act and rules, as well as orders made by the Karnataka State Election Commission. The court observed that the whole process and the procedure is to bring transparency in the process of election. And each candidate has to furnish their past history, family background, education, age, marital, material status, assets and liabilities, mobile and immobile properties held by the candidates and their family members at the time of filing nomination papers for any election with full and complete information. And accordingly, allowed the petition filed with respondent number 1 herein. Agreed thereby. The appellant is before this court. Learned counsel for the appellant submits that the respondent number 1 herein has not disclosed all the relevant factors and also about the criminal cases that are pending against him, and with regard to the family details of the family members, and all the relevant details were not furnished by him. In that case, he is not entitled to be declared as a elected candidate. It is submitted that the plea of the appellant that he is not aware of the pending, the CC was not considered by the trial court. He submits that the court ought not to have declared the election of the appellant as void, and without considering his plea with regard to the allegations against the respondent number 1. The respondent number 1 is declared as a candidate for ward number 7, which is not correct and which is contrary to law. Next para. Learned counsel appearing for the respondent, first respondent petitioner, submits that he has not suppressed any of the material facts, and he is the one who has questioned the election of the appellant herein. And considering exhibit P8, considering exhibit P8, court had rightly come to the conclusion that there is suppression and misrepresentation. P10, and there is suppression and misrepresentation, and rightly allowed a petition filed under section 21 of the Karnataka Municipalities Act. It is submitted that if it is the case of the appellant that the respondent has suppressed any material facts as any criminal cases are pending against him, he should have brought all those things on record. And he submits that these contentions are raised before this court, and in that regard, no issue is framed by the trial court, and the appellant herein has never insisted upon the trial court to frame such an issue. Now it is not open for him to question the said question. He cannot raise such an issue before this court while impugning the judgment, by impugning the order. Next para, same para. He submits that the trial court had rightly considered all the issues and no grounds are made out seeking interference with the well-considered order passed by the court below. Next, having heard the counsels on either side, there is a material on record. The whole dispute revolves around the fact whether there is suppression or misrepresentation of facts, and whether the appellant had disclosed the relevant details as required under in the nomination form. No, either of it is undisputed fact that the party has to disclose the pending cases against the candidates, and also the cases where the charge sheet is filed, and the sentence is about 2 years. A charge sheet is filed against the petitioner, against the appellant, that is CC number 1313 of 2018 on the file of the Principal Civil Judge Court under section so and so, whatever earlier you have written, no? The text, right? And the maximum punishment is 7 years. In that case, it is incumbent upon the appellant to disclose all the details which he failed to do so. And the court had rightly held that in the view of the section 21 of the municipalities, Karnataka Municipalities Act is attracted and declared the election of the appellant and had set aside declared the election as void, and the same was set aside. Next, coming to the contention that the first respondent had not disclosed certain details and certain complaints are pending against him. For that, the evidence is required and no such evidence is adduced before the trial court, neither such evidence is placed before the court, nor any issue is made by the court, by the court in that regard. In such case, this court cannot, in such case, it is not open for the appellant to raise all these issues, all those issues before this court. In the considered opinion of this court, the trial court had rightly dealt with the issue and set aside the election. The appellant, this court finds no reasons to interfere. Accordingly dismissed. Yes, next.
Cell number 19.
Yes. Yes, next.
Cell number 19. Sheshgiri Rao.
Yes. Coming up for the first time?
Yes.
Yes. What is
the nature of the suit is it is used for injunction. And not the learned trial is not by virtue of the order. The lordship may turn over to 62 for a moment.
You are the plaintiff in the suit.
Stand the defendant.
Injunction is granted.
Quite an injunction, not it says status quo ante relating back to the date of filing of the suit. This is where we don't know what is the nature of these cases.
What is the case of the plaintiff?
But the case of the plaintiff not is that right from 2013 the matter was agitated before in a declaratory suit, which ended up in 2002 before the honorable court because wrongly the suit was filed in the name of an association, it was withdrawn, and thereafter my lord's suit has been filed later on in the individual name of the plaintiff. This is the commencement of the plea. Then there is a plea by the plaintiff to the effect that there was a sale deed which has been executed by one Mr. Shetty in favor of the original plaintiff. And that sale deed does not have any genesis, that is backward trace of title. On the basis of that title, not an unidentifiable strip, not sought to be engaged in a dispute. No, not. Why this has come up before the court for one moment. But the learned trial did not, if I could just point out, points for consideration started running page 45.
Yes.
Running page 45. The lordship could see that 45 to 58 not. They are all recitations of various case laws. I don't think none of which are wrong at all. 45 to 58. Now, not the reasons will only start from para 18, not 59. Could I read that?
1 minute. Please come to page 59, para 18.
Please, Milods. Lordships are at 22/12/2003.
Page 59,
Yes, Milods.
para 18.
Yes, Milods. Milods, now these are the reasonings, Milods, what the learned trial judge offers. At this juncture, it is palpable from the records that the plaintiff has maintained the instant suit, seeking relief of permanent injunction in respect of the suit schedule property on the count that the plaintiff is the absolute owner of the suit schedule property on the backdrop of the sale deed cited supra, which came to be executed by erstwhile owner Sri Ramai Shetty on 22/12/2003. On contra, it is the urgent surge of the defendant that the plaintiff at no point of time is owner of the property in list, wherein depicting wrong number boundaries and extent has come up with vituperative suit. And factually, it is the defendant who is the absolute owner in possession of the suit schedule property. Time immemorial, by virtue of a gift deed dated 4/12/2006, widow of the deceased Narayanappa, Srimati Irama had gifted said 9 guntas of land in survey number 55 in favor of this defendant. At this juncture, when the
What is the nature of the property?
Minots, it's a landed property. Minots, now it is vacant. Kindly see, Minots. The only point on which Minots I am just trying to lay emphasis is this.
Status quo is granted now.
Status quo with yes, Minots. Status quo is absolutely granted.
So what is happening?
Now, Minots, status quo with respect to what portion? This is Minots. Kindly see the operative portion of this order, Minots. We'll see this.
Filed with the applicant so and so.
Yes, Minots. At
Party
62.
allowed.
62 for a moment. The second unnumbered para there too. In light of the given set of circumstances to strive harmonious relationship amongst parties to this and to preserve the identity of
Suit schedule property, antements.
which I'm not able to garner the meaning of what is the ante position in respect.
When did you purchase the property?
No, sir. I come. Not sir. This is a ancestral property belonging to me, and there's a gift ultimately in within the family. So,
Here.
Big minute.
Year. Which is it?
2006. 2006. Now,
Their sale deed is 2003.
Their sale deed is of the year 2003. And their sale deed does not have the backing of the true owner there.
What is this, what is the property gifted or by way of the gift deed you got?
I own around 9 guntas within I own around 9 guntas within survey number 55.
And what is the suit schedule property?
The suit schedule property is said to be covering around 16,000 square feet. 9 guntas would be around roughly around 9,900 odd square feet.
More than that.
Approximately.
More than your land.
1089 into 9 minutes.
More than your land.
No, their land is around, I would say around 15 guntas. 15 guntas. So now the only point is this, minutes. The only point is this. Minutes, what is the title? The title forms the genesis of any one of these vacant lands.
No, we'll say that you maintain status quo. It's a
status quo with respect. The whole point is that is an unidentified patch. One. Secondly, the dispute has been in position from 2013. And there is a title, there was a title suit filed, it was dismissed by claiming it is belonging to the church. Now the person who comes before the court is the I have to say the archbishop or the bishop of one of the churches. He says that I have come in my personal capacity here.
Now, by modifying, by clarifying at this point of time,
3 minutes.
Unnecessarily it gives rise to another issue and another litigation. Better it is you take a notice, the hand summons on the counsel appearing for the respondents and file a memo to that. The moment you file the memo, it will be listed. I'll pass such an order.
Only point is, we are not
What
able
is
to
happening
understand.
is already in a suit, some order is passed.
There is an order, and
Now again clarifying it, and now with the clarification, you doing something else.
No, kindly see, this is running from 2013. There must be an end to litigation. It is like
Take the counsel for the appellant is permitted to take out hand summons on the counsel appearing for the respondent before the trial court.
Yes.
And shall file a memo to that effect.
You-
Once the notice is,
Yes.
once the memo is filed, the matter shall be listed on the next day.
Might I request it in this form? If your lordship's board is free for 9th or 10th of the
And I said, the moment you file, it shall be listed the next date.
Very well, notes. I know that, but my, the registry might be overloaded with cases because of the impending
Which
vacation.
date?
9th or 10th of the next September.
Can
I-
you do it? Post this matter on 10 September.
If it is, yes, I'm great.
Yes, next.
Then number
If the memo is filed.
I'll do that.
Serving
I'll do
notice
that
of
before
so and
second.
so, then it should be listed.
I'll do that
Yes,
before
yes,
second.
yes,
My
yes.
undertaking may be taken. up. Great.
Yes.
Srinivas B.
What is the order?
Lord, maintenance have been granted,
How
but
much?
the petitioner is also aged about 63 years.
Hmm.
Husband and wife is 51 years as on the date of petition.
Hmm.
Admittedly, both are, he is a senior citizen, he is a retired KSRTC employee. Now, my lord, in the cross examination, she has clearly admitted that he is getting only 3,007 rupees as his pension.
How much the court has granted?
15,000, my lord.
Please come to the order. Why the court?
My
will
lord, it
grant?
has never discussed regarding cross examination. 10,000, I'm sorry, 10,000 rupees is granted. It has never discussed the cross examination portion at all. In the cross examination, she
And counsel for
admits.
the appellant submits that the appellant is a senior citizen, age is 63 years, and the wife is 51
As on the date of filing, now she
51
is
years
50.
old, and in the cross examination, it is stated, it is admitted that the husband is a retired employee and his pension is 3,000 and odd,
3,007 rupees.
3,007 rupees. In spite of the same, the court had granted
10,000 rupees per month.
10,000 as maintenance, considering the submissions. There shall be stay of all further proceedings. Pursuant to the order dated 9th July 2024, criminal miscellaneous number 292 of 2022. The registry shall issue emergent notice to the respondent.
Lord, I'm seeking stay, my lord, otherwise she will seek
Stay.
much.
Yes,
Number
next.
24. Bindu U for petitioner. PB Raju. For respondent.
What are your instructions? Instructions.
I'll continue to pay the school fees, my lord. Your fees also I'll pay. I pay every month another 5,000 rupees I pay. Almost say 25,000 rupees will come.
How much it comes?
Almost 25,000 will come per month. 1,80,000 that will be. That 1,80,000 I'll pay.
What is the yearly fees?
They're not.
This
What is
year
the-
is 1,70,000. That's the instruction.
1,70,000 is the yearly school fees.
Yes, yes, my lord.
How much you paid on the? Hmm,
I'll continue, next year also I'll pay.
hmm.
Full school fees I'm taking care of. Additional 5,000 per month I'm giving.
What about the monthly maintenance and all, my lords?
Court has granted how much?
25,000 per month
the
only
court
to
has
the minor
granted
child.
Apart from the educational or along with the education?
Along with the
Put together.
everything.
So
Totally,
now according to you, how much it will be? If you pay 1,70,000,
Almost about 15,000 rupees per month.
15,000 per month.
20,000 rupees I'm paying. 25,000 is different because she has huge assets. She
no, my
also-
lords, all these are matter under pending under consideration.
Uh-huh.
So the impugned, what the trial court order is that 25,000 per month for the minor child only. As such, for that amount itself, they have come on their appeal. In my case, my lords, the wife has not been granted any maintenance and litigation amount also in a very lower side, my lords. As such, I'm in this connected writ petition, my lords. Now,
So first, that 25,000, whatever is question granted and whatever is questioned by them. Now, if with this calculation, no, how come, why can't 10,000 per month?
22,000 I'm paying.
10,000. Let him pay 10,000 per month, along, apart from that school fees. And we'll keep this pending, this writ petition. Let it go on, let the visitation go on for some time. Then we'll pass final orders.
God has granted these.
I'm not clear about this suggestion by my friend, my lords.
No.
25,000.
No, he has already paid
Yes.
1,70,000.
70,000, yes.
And No, he says it comes to 15,000 per month.
Yes, ma'am.
1 second, I'll check it, my lords.
15,000 per month.
Hmm.
Now, what this court will direct is to pay another 10,000 maintenance to the child. It becomes 25,000 per month.
So my lords, the educational expenses once in a year will be paid, and apart from that, 15,000 every month.
10,000.
10,000
Not
every
15,000,
month.
10,000. It becomes 25,000 as given by the trial court, as far as the child is concerned.
Okay.
Now, let him exercise the visitation for some time. Let this arrangement go on. Then we will pass further orders later point of time.
And as regard to the wife's maintenance, my lords?
That's what, that's a final order. That we will consider.
I have to check with my client
Huh?
also. I have to get instructions also, my lords, if this is the way means.
No, I'm not disposing it off.
Okay, keeping
Not
pending the writ petition.
Keeping pending this monthly 10,000, the visitation will go on. We'll post it on some other day. So in the meantime, we will also see that how things are going on. Now, from when he is not paying the maintenance according to you?
From the 2017, when she has been thrown out
Right.
of the
So,
matrimonial home from
no,
that
already
onwards, my lords.
1 year is, 1 year's fees and
Yes.
50, that is 1 year, almost 1 year arrears. A part of it is completed now by the school fees.
Yes, my lords.
As per the order of the court is when?
Yes, my lords.
Order of the court is? Is it from the date of petition or from the date of order?
From the date of petition, my lords, application, from the date of
Application is when?
application. Yes, my lords, in the year 2018, 1/1/2018, the application has been filed. So as on today, considering that. it
That
will be
also we
about
will see.
20 lakhs,
That
my
also
lords,
we
sir.
will see.
And
Now,
if-
what about the visitation? He didn't go on the last occasion.
Yes, diarrhea, he had some problems. Saturday evening and Sunday morning maybe.
Give that last time order. Order. When the matter came up on the last occasion, that is on 23/8/2024. This court has permitted the father to exercise the visitation on 5/8/2024 between 10 AM to 12 noon. And directed the matter to be listed today. Today, when the matter came up, then counsel appearing for the mother submits that the father, as per the order passed by this court, has not exercised the visitation. Then counsel appearing for the father submits that the because of some personal reasons that they could not visit the child. It is submitted that apart from paying the yearly school fees for the boy, the father for the girl, the father is ready to pay monthly maintenance of 10,000 per month. It is submitted that the court may grant visitation the father so that the father will get an opportunity to develop the bonding with the child who is age
I think 11 years.
10
who is
years, my lord.
10 years old. Considering the submission, the land counsel appearing for the mother submits that when the trial court had granted 25,000 to the boy and no maintenance is granted to the wife, she had questioned the same by filing this appeal. It is submitted that the mother is not in a position to support her, which is denied with the land counsel for the father submitting that she had enough resources and all that, and considering all these facts, court had not granted maintenance. At this point of time, this court is not inclined to go into the issue of maintenance of mother, considering the fact that already the fees is paid and the father is ready to pay 10,000 per month, which comes to almost 25,000 as per the order of the court. This court is passing the following order. 1, by 5th of every succeeding month, the father shall pay an amount of rupees 10,000 to the daughter. Next, on every Saturday,
Saturday evening.
Saturday evening between 4 and 7,
4 to 6, my lord.
or 4 to 6, and again on Sunday on between 10 to 12. Between 10 to 12, the father can exercise the visitation. He can go to the, what was earlier or not?
The residence of the mother.
1 minute. The father can go to the mother's place for exercising the visitation. Both the parties shall cooperate. The mother shall cooperate and father shall also not create any kind of inconvenience either to the mother or to the child.
That's it. What is that? Same thing only. And one more clarification now, what about the arrears, my lord? So this will come.
That we will decide.
It will be
That we will decide. Suppose this matter, 1 minute.
They can give me.
Huh?
School fee receipt, they should give it to me.
What receipt? No, she has already made the payment.
Must give
No,
me
he's.
the receipt.
No,
How is it?
how much is the money that's paid?
1,70,000, that is the instruction as per that which
No,
he has
that
already paid for
you must
this.
have paid the school.
Yes, my lord.
You must have.
Sorry.
Wow. All the while you don't even take care of the child and suddenly you come and say that you want the fees.
Not that.
Pose this matter. Unnecessarily, you people are rupturing it on the wrong side.
Money, that school fee receipt I am entitled to. In all
September,
fairness, that
what
is
do you
not
do with that?
What I will do with that,
No, definitely, it's not your case that she is not paying the school fees and only for the purpose of extracting money from you, she is doing.
what is the difficulty for them to give it to me? Well, let me
This,
tell
you have already.
It is paid by.
1 minute, you have paid the school fees, it
She
is
has
not
paid for this year.
that you will have a receipt. Next
I don't
time
know
pay
through
before
whom
the.
she has made the
Uh-huh.
payment and I don't know through whom she has made the payment, whether through her mother or brother or whatever it is. I'll
What is
check
that?
it with my, no, school
No,
fees
no,
already made.
somebody has paid the
Yes,
school
yes,
fees to the school.
Yes, yes, ma'am.
School will give the receipt.
Yes,
That
yes.
receipt you can place before the court
Oh, please.
as far as
I
that
will- I will-
amount is concerned.
Sure.
Pose this matter on September 2019. Yes.
Yes, please.
Cell number 25. KP
Yes.
Bhuvan. 25 KP Bhuvan. Acknowledgement is filed.
Non-filing of acknowledgement for having paid the maintenance. You are paid?
Every month I'm paying on first, I serve the
then
copy to the
There
opposite.
is no representation on behalf of the respondents. Then counsel for the petitioner submits that as per the order of the court. He has
Complaint.
been continuously paying the maintenance. Pose this matter,
And call for records, my lord.
pose this matter for final hearing. Admit, pose the matter for final hearing. Registry is directed to call for the lower court record.
Delete.
Delete from the caption for dismissal. Next.
Cell number 26. Harish R for petitioner.
Give that. As there is no representation. On 31/7/2024, at request, the matter is posted to 22/8/2024. On 22/8/2024, there is no representation. And this court has directed the matter to be listed under the caption for dismissal. Today also, there is no. No. Today there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to pursue the matter. Accordingly, the petition is dismissed for non-prosecution. This next.
27, 28 adjourned. Cell number 29.
Yes, that's what we'll issue notice in that.
That's 29.
I represent the caveat.
What is this complete application?
Before going to the pleading application, what my suggestion
No,
is
no,
that
he is not ready to argue. So, because there is an implied.
This is all unnecessary appeal. There are two similar applications filed before the trial court, 39 for June 1, seeking different injunctions. Both the applications have been heard by the trial court and both the applications on merit has been rejected by the honorable
what-
trial.
On different
grounds we have
filed, Your Honor. What is this IA for
39
implied?
rule 1 for not to alienate the.
Not that. Why you are saying that this IA should not be, this implied petitions are not
They
necessary?
are unnecessarily, they want to prolong with the matter. That's all.
What are the implied-
has to be added.
Please wait. What are these implied petitions?
That they will have to say. This
Oh, you are saying that it is not necessary. So then you must be knowing it.
Already, only because of this case, the trial court is not proceeding with the matter. I'm leaving it.
At the request of non-counsel for the appellant, pose this matter on 9th of September.
Much.
Yes, next.
Please,
Third.
Your Honor.
30,
Notice to the respondents,
The matter is
there is a delay of 182 days.
82 days. plus.
Notice,
No, my lords, my
31,
only submission is this. There was a petition before the trial court. The petitioner was advised to file this petition before the trial court, wherein the earlier counsel had filed a petition challenging the same order before the same court. After I got NOC, I advised him to file a petition before this court. That is the only cause for the delay. Now,
no, whatever is reason,
please.
no, this order cannot be stayed now without a notice to the respondents. We have to condone the delay.
Lords, my another submission is this. If my lords, if I may persuade my lords to take page number 328.
Take out notice.
No, my lords, the respondent number 1 is continuously living in adultery. In spite of that,
The first respondent, the registry is directed to issue
Lords,
emergent notice to the respondent.
no,
Pose
lords,
this
I've
matter
been
on,
paying, I've paid almost 13 lakhs to the respondents till date.
how much is the amount you have to pay?
I have to pay 24 lakhs is what they are claiming. I've already paid 13 lakhs
How
in
much
the
you will pay?
execution petition. Tomorrow is the matter listed. Because if
How
I,
much you will pay?
that's the reason I'm saying right from the inception and right from
No,
the,
if it is on that, then I have to hear it on the merits, is it not?
please, my lord, but at least if I may persuade my lords, at least till the notice is served on the respondent, the matter may be
There can't
stayed.
be a blanket stay.
No, but it's because
Then-
there is a birth certificate and there are
True,
photographs.
on some payment, there will be an order. Otherwise, stay will not be granted in all these matters. Because now the
She is
respondent
openly,
shall come and the court has to appreciate everything.
please, my lord, no, the only submission is this, because she is living in adultery right
How
from
can the court
2013.
decide this, that whether she's living in adultery or not in
That's the
RPFC?
reason, if I may persuade my lords to take page number 328
What the court
for a
said?
moment. It's a birth certificate of a child.
Not about it. What is the order of the court? What is the finding? What is the finding of the court? No, all those documents, this court will appreciate now.
No, at least, I mean, the names are mentioned. The father name is mentioned as somebody else. I have been paying
The-
maintenance right from the date of the order passed by
For
the
proving
trial
the
court.
document, some evidence is required.
This was the birth certificate which we got pursuant to the order.
In the other case, morning I saw, there are two birth certificates unconnected. In one, there is name of the mother, in one, there is name of father. So just like
I
that,
agree,
you
I
can't
was
take
there,
the
I was there
documents.
when the matter was heard. But during those times, there might be some issues. These are all
That's the
computer
latest one.
generated.
What, even the ES file is also a latest one.
Please, madam, this is also computer generated one.
That is also
for a
computer
moment,
generated one.
For a moment, if my lords may take this,
If you want two things. One, I will issue emergent notice to the respondents. Two, if you want stay on some condition.
not, or if I may. Lords, page number,
When there is an order, if you don't come to the
77
court
maybe.
and file it appropriate time, warrant will be issued.
no, my lords, because I got NOC brief.
It's not about you or some other advocate, it's
Because
about your party.
I can't.
You can't
any
help it, your
allegation-
party has to help it.
True, but at the end of the day, he's been suffering, my lords. If
What to do?
for at
If
least a
somebody
moment,
is not vigilant, he'll suffer.
for at least a moment, if I may persuade my lords to take page number 77, my lord. Because this is the order sheet wherein he has been paying, he has paid 5 lakhs
Where
DD.
unless, no, whenever there is a
Yes,
delay in those kind of matters, there without condoning the delay, question of considering the next IA will not arise at all.
That's the reason I made a submission before the court that the earlier council had filed a petition.
All, you're again going revolving around the same issue. For registry is directed to issue emergent notices respondent. Post this matter on
But if I may.
18th of
if-
September.
Or at least till the respondent appear before the court, there shall be an interim order of stay. Because I've already paid 13 lakhs to the respondent number 1.
Pay remaining also.
Till number 31.
That's why I'm saying on some condition it will be not on a blanket order.
The entire order sheet speaks that she has received the amount. Entire order sheet, there is a signature.
Some more amount, that's what I'm saying. If you're ready to pay some more amount, then we'll grant stay.
Lords, I've been continuously paying, my lord, and if the court insists, we can pay a little amount.
You said 24 lakhs. And you're saying that you have paid 13 lakhs.
We have paid 13 lakhs still.
Hmm.
We have paid already more than half of the amount was what they have claimed.
Then counsel for the petitioner submits that the court without considering any of the facts that respondent is living in adultery and that she is not entitled for maintenance. Had granted maintenance of an amount of rupees,
24 lakhs.
lump sum amount.
Yes, madam.
Granted
The court had ordered for 10 lakhs for 10,000 for respondent number 1 and 15,000 for.
Granted 25,000 as maintenance. It is submitted that they have already paid an amount of rupees 13,000, 13 lakhs. 13 lakhs. Considering the submission of the learned counsel, there shall be stay of all further proceedings pursuant to the order dated so and so on the condition that we shall deposit another 2 lakhs by within 4 weeks from the date of receipt of the copy of the order.
6 weeks.
Yes. If the amount is not deposited, the order granted by this court stands vacated without further reference to the court.
Great.
Yes, next.
Till number 31. Ramachandraya.
Petitioner, madam, this case. Petitioner is working as, respondent working as a doctor, non-doctor. Petitioner is a male nurse, my lord. And there is honorable tribunal, family court has passed the order. Event is one of the marriage.
What is your salary? What is her salary?
Please, ma'am.
What is your salary? What is her salary?
One, my lord. That petitioner and respondent are married according to Muhammadan law, my lord. They are lived together only 6 months. Thereafter, she left the matrimonial.
You filed under 125 CRP.
Yes, please, for CRP
Yes.
120.
So what is the income of your?
I only I petitioner is only I completed diploma in male nursing, my lord.
Income is not there.
No, my lord. That is she is a doctor, doctor. She is having a nursing home all besides the task.
What is her income?
It is more than 50,000 rupees, my lord.
More than?
More than 50,000 rupees is there.
As per the order of the trial court, what is her income?
15,000 rupees they awarded, my lord. 15,000 rupees, 1 5.
Give the file.
And already the file is announcement of seeking. It was rejected with Sambar court itself.
Where is the order sheet? Where is order sheet?
Next year, yeah, my lord. Page 13 and 14. The trial court, they are not accorded this petition, respondent is not a doctor. But that is very clearly, I enrolled by as a doctor, and doctor. I am working as an.
Say that you're saying that you're a male nurse. Court records that you're a BMBS doctor.
That is, he is a doctor. I am not, I am only the diploma nursing. Can you see the documents appraised, my lord? Next year. I completed diploma nursing.
petitioner is wife,
Please, petitioner,
respondent is husband.
please, my lord.
What is your Dr. Syed Sadat?
Sadat, I am a male nurse, my lord.
Male nurse is a doctor.
No, no, no. She is a respondent is a doctor.
No, I'm asking you as per the cause title.
Please,
Cause title is Dr. Syed Sadat,
whatever that,
page number 13.
Allah, that it is a misleaded and misrepresentation because the trial court and my learned brother counsel has not prosecuted properly. That is why I came before.
Then let other brother also come on the respondent side, we'll see.
No, my lord. Otherly, this is a doctor. She has been more than no husband. I am only the male nurse.
The registry is directed to issue emergency notice to the respondent. If the notice is served, post this matter on 23rd September.
On submission, my lord. Emergency, the NBW issued annexure D, my lord.
When was the order passed?
It is on 26/4, my lord. 24/6 last year.
No.
Annexure
What
D.
is the amount you're going to deposit?
I will leave it to the court. I already paid 40,000 rupees, my lord.
How much is the maintenance granted? 10,000.
10,000 rupees.
When is this petition filed for maintenance?
That is 2019, my lord.
2019.
Please. So 2021, 19, but 21.
21 is a petition. Which month?
It is in the month of
Look at it. What is the date of petition?
21/9/2021, my lord.
21/9/2021.
For which I have already paid 40,000 rupees.
Please come. Then counsel for the petitioner submits that the petitioner, the wife is a doctor and the husband is a male nurse. But the male nurse, she's earning more than the husband. And this aspect is not considered by the trial court. This court has perused the cause title. As per the cause title, it shows that he is a doctor. And counsel submits that the counsel appearing before the trial court on behalf of the husband has not pursued the matter. Considering the submissions of the counsel for the petitioner, he shall be stay or fall for the proceedings on the condition that he shall continue to pay 5,000 by 5th of every succeeding month. And as this petition is filed on 21/9/2021 for 3 years, that is 36 months at 5,000 comes to 1,80,000. The said amount shall be paid within 12 weeks from the date of receipt of the copy of the order, default order, either 5th of every succeeding month or so and so. The stay granted by this court stands vacated. Registry is directed to issue notice to the respondent, pose this matter on 14th of, not 14th, 16th of October. Emergent notice to the respondent. Yes. Next.
This kindly to more than number of factors. And the Monday's case is there.
Tomorrow is a working day.
It will be
uploaded
in the trial court, my lord. In trial court. I will collect it tomorrow morning, no problem. I will collect it tomorrow morning. Monday's case is there. Monday case is there. That is I'm requesting.
Yes. Second list.
430 matters. Serial number 1. Rajeshwari M. Compliance for second time.
Any time is mentioned, 4:30. Yes. No representation for dismissal. Tomorrow same 4:30. Yes.
Serial
Two.
number 2.
I pray for 1 week time and I am appearing for appellant
In which case?
second matter, my lord.
Why did you, this is for the second time?
My lord, first time, my lord, that matter was before register, my lord, several objections have
A
been
week's time
complied.
is granted for complying the office objections. Same default order. Next.
Number 3 it is 4.
No, it is 2. 3 is withdrawn.
It's
Yes,
4.
4.
Amar Gowda case.
No representation for dismissal tomorrow.
Cell number 5.
Same, no representation for dismissal tomorrow.
Cell number 6.
Same at 4:30 tomorrow, same. list.
My lord, serial number 6.
Uh-huh.
Week's time may be granted, my lord.
Yes,
within 8
week's time default order.
Cell number 7.
Your lordship, appearing for the petitioner, I request for a very short accommodation, your lordship. KVIT has to be served, your lordship, in this matter.
Please serve.
Please,
MFA 2023, you are not serving the copy
Just-
to the caveator.
Your lordship, acknowledgement has to be filed. I'll file it, your lordship. Just 1 week period, your
Served,
lordship.
papers are served. The
Lordship.
post is martyred day after tomorrow, not day after, on Monday. On Monday at 4:30. By the time if the papers are not served on the caveator, the appeal shall stand dismissed.
Much obliged, your lordship.
Yes.
My lord, in this case, kindly have a 6th my lord, by that time, I will comply all the office subjects.
Finally,
6th my.
post is matter on 6, default order. Yes, next.
Cell number 9.
This is also same. This is.
4th time, 5th time, 6th time. Same, 9 also same. On the day. 10,
Cell number 10.
no representation tomorrow for dismissal.
Cell number 11.
Same,
Cell number 12.
same,
Cell number 13.
same order.
Cell number 14.
Same.
Cell
Same.
number 15.
Yes, tomorrow. All these for dismissal tomorrow at 4:30. Yes. What happened? One more matter is there. 15 is done. Where it? Oh,
40.
yes. Give that, Kaka, we'll complete the signature and then you can. Yes.
40. Admission at 40.
Yeah. May I
What
please?
is this, sir?
40.
May I please?
Admission at 4:30 PM.
Yes, it's, I'm so sorry, my lord, it's only,
This court has passed. Why?
my lord, your lordship may kindly issue notice in this case, it's,
For compliance of office objections, post this matter on, if the office objections are not complied with, the appeal shall stand dismissed without further reference to the court.
no, this has already been complied, when no office object, file number 40.
Oh, it's coming up for admission.
Please.
What is the case?
And my lord, there was an injunction order not to create an encumbrance, not to alienate. Despite that, an alienation has happened.
Notice
By
to
way
the
of-
respondent.
Please.
Notice to the respondents, appellant is permitted to take out notice on the
Please.
counsel appearing, hand summons, not no, hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect. Yes,
that,
41.
please, grateful.
Memo to that effect, if the memo is filed,
Since the matter is disposed of, should I, my lord, should I permit, it be directly
It is
noticed today? It is
MFA?
disposed, it is disposed. That as petition has been dismissed. My lord, disobedience application was filed for disobedience, my lords, of the order.
no.
Injunction was
MFA is arising
granted.
out of
A
intermediate.
MFA is arising out of an application filed for taking action for disobedience. That petition has been dismissed, please. Therefore, no notice
But
to
the suit
respond.
is pending.
No, my lord, this is only injunction order. Main suit has been allowed in favor of the party now, or in favor of the plaintiff.
Oh,
Suit
it's
has been
only
decreed.
non-compliance of the order. In
Yes.
execution petition, this is
There was an injunction order. Despite injunction order, some alienation taken place by way of registered document.
Emergent notice to the respondent.
Please. I'm grateful.
Yes.
41, Radha
My lord, in this
Kumar.
appearing for petition, in this matter,
Who appears? Harish Kumar and his,
other side colleague had,
he is not there.
he is not there. But in this matter, my lord, the matter has been settled before the family court. The divorce has been granted and the settlement report has been also filed, my lord. It has to be considered.
It is filed before this court.
It has filed before this court only.
Post this matter tomorrow on the top of the list.
It
You
are
are-
already filed because one more
No,
mistake.
let the respondent be here. Tomorrow on the top of the list. First matter, it will come.
First matter,
Tomorrow on the top of the list.
on the 30th, 700.
Doesn't take, which one? It is dismissal also in 4:30. Yes. Okay.
ಯಾವ್ದು ಯಾವ್ದು? ಹ್ಮ್.
6-9.
Two.
6-9. 2-9.
ಯಾವ್ದು?
6-9.
Serial number?
7. 7.
29 ಅದು. 29 at 4:30. If not complied. ಅದೆಲ್ಲ ಪರ್ಎಂಪ್ಟರಿ ಆರ್ಡರ್ ತರ. Not complied for 6-9 ಇನ್ನೆರಡು ನೆಕ್ಸ್ಟ್ 8 and 9. RP ಸೋಮಶೇಖರಯ್ಯ ಅವರು.
6 and 9 ಅಲ್ಲ 8 and 9 6-9. ಅದೇ 1 week's time.